Wait, please. Lordship, I beg to mention item 12.
Yes.
Lordship, in this matter, I am led by Senior Counsel Mr. P.K. Goswami. He was scheduled to appear in this matter. Just some not well, Lordship. Can it be after 2 days, Lordship?
After?
2 days.
Okay. On the prayer of Mr.
Now, 18 or 19, any day, Lordship. Convenient.
Mr. B.P. Bora, and counsel for the petitioner. First, is the case Thursday.
Diplo.
May I please, your lordship? I beg to mention for listing of a matter, my lord, criminal petition, my lord. It was filed on 12th of December, my lord. For motion, my lord.
Okay.
May I please, your-
Thursday.
may I please, your lordship? Lordship, I beg to mention item number 13, your lordship.
13.
13, your
Yes.
We are seeking some instructions from our client, your lordship. We have not received till yet. Any after vacation, your lordship.
On the prayer of Mr.
P. Daimari, your lordship.
P. Damari, and counsel for the petitioner. List the case on. Did you go? First.
9-1.
Please, your lordship.
Wait, please, your lordship. Lordship, I beg to mention a listing of a criminal petition, lordship. Lordship,
Motion.
criminal petition, lordship.
Motion.
Motion, lordship. Lordship, there is a certain urgency, lordship, because on the trial court date is on fixed on 8/1/2026, lordship, and
Thursday.
a distress warrant has been issued against our
Huh?
petitioner, lordship.
Thursday.
Much obliged, lordship.
May I please, Lordship? I beg to mention item number 29. Lordship, kindly adjourn the matter for the day. Due to some personal difficulties, my senior
29.
did not attend the court to
The prayer of Miss.
E. Devi. I am appearing on behalf of K.U. Ahmad.
Your name, please.
E. Devi.
Learned counsel on behalf of Mr. K.U. Ahmed, learned counsel for the appellant. The case is adjourned for 2 weeks. Miss, you have informed the other side.
Yes,
Mr. M.P. Goswami, learned additional public prosecutor for the respondent number 1. And amicus, learned legal aid counsel has been informed.
yes, Lordship.
Okay. It is submitted that counsel has been taken from the learned counsel for the learned legal aid counsel for the respondent number 2. First of praise aloud, list the case after 2 weeks.
It please, your lordship. Lordship, may I pray for list of a criminal revision
Motion.
petition Friday?
Thursday.
May I please, your lordship? I beg to mention one criminal petition for listing for motion on tomorrow, my lord. Because,
What is the urgency?
my lord, I have challenged the NBW and
Huh?
case is fixed on 18 before the trial court, my lord.
18?
18. Day after tomorrow.
When it was issued? When started issuing NBW?
Long back.
Long back. No urgency. Thursday.
Always.
May it please, your lordship. I beg to mention item number 4, prayer for passover of the matter.
Passover?
Yes. Yes, lordship.
Okay, on the prayer of Mr.
Edeka.
Edeka, learned counsel for the petitioner. This is Passover for the day.
Daily list for motion, item 1.
May I please, your lordship?
Hmm.
Lordship, this is an application. Under section 397 of the CRPC and under section 476 of BNSS for modification and correction of the impugned judgment dated 18/8/2025 passed by the learned Principal Judge Family Court number 1, Kamrup, Guwahati, Assam. Lordship, in FC criminal case number 354/21 filed under section 125 of the CRPC. Lordship, actually what happens in this case, I'm the husband. I'm 60% I'm disabled person, physically disabled person, and annexure B, page 71 to 72. It reflects that I am 60% disabled person, and the same is reflected in the impugned order, lordship, order as well as judgment. Page 71, which has already been exhibited before the trial court as exhibit 1, lordship. Lordship got it? Annexure B.
Well, you should notice at this stage
Lordship, humble submission before this Lordship is because pending area, all these things, more than 3,65,000 has already been directed. I have been directed to pay within 6 months from the date of order. So the impugned order may kindly be stayed. Otherwise, as because my salary has been deducted, I've been demoted from the post of assistant accounts.
Your own statement says
Lordship, recent after
32,000.
32,000,
You
Lordship, kindly.
yourself stated that your salary is 32,000.
Yes, Lordship, kindly.
And 8,000 is the maintenance allowance directed.
32,000. Yeah,
So
yeah.
we can't
It was
help
previously, Lordship. Kindly see annexure L, Lordship, page number 171, 72, that I have been demoted due to my physical deterioration and I am under the medical treatment of physiotherapist. So, relevant relevant, that is annexure M reveals that my salary has been
Deposit 50% of the area salary.
50,000. It has been, my salary has been reduced to 50,000, 15,000, and out of 50,000, 15,000 I
You
am
are
paying.
not, you are private employee.
Lordship,
Where this can be done
Lordship,
with-
kindly, I'm 165% disabled person, Lordship. This is,
That I know, in spite of
Lordship,
that,
Lordship,
it is 32,000 as per your own statement.
no, subsequently it has been degraded, Lordship.
You work in a private company.
Lordship. Lordship,
I'll not say much.
yeah, Lordship,
We are issuing notice.
Lordship, my humble submission may kindly be appreciated that the Rajneesh versus Neha 2020 Supreme Court itself says that if the prosecution fails to prove that negligence on the part of the prosecution that is inflicted by me, then she is not entitled to get the undue advantage of the judgment is along with me, Lordship. I'll place. And here in this evidence as well as petition also, she never whispered that she has been neglected. So under these circumstances, she is not entitled to take the undue advantage of this place. And if the order, imprint order, is not been stayed by this honorable court today, then I am to pay within 6 months. That is 3 lakhs, more than 3 lakhs
It is a
65.
region judgment after appreciation of evidence
And Lordship,
by the parties.
trial court has passed. That is violating the section 104 of a BNSS.
What is
Here's a-
104 BNSS?
So, Lordship, here's the evidence. Trial court has passed the that is the PW2, PW3, all are stated that on hearsay they have adduced their evidence.
But
And
Mr. J.P. Das, Learned Counsel for the petition, this criminal revision petition. Under section 476, Bharatiya Nagorik Surakha Honita 2023 is preferred to assail a judgment dated 18/8/2025 passed by the Court of Learned Principal Judge, Family Court, Kamrup at Guwahati, the Family Court for short, in FC within bracket CRL is 144, number 354 of 2021, full stop. The case, comma, FC CRL 354 2021 was registered on institution on filing of an application by the respondent under section 125 CRPC, Code of Criminal Procedure, seeking maintenance allowance from the petition, full stop. Para. Sorry, by the judgment dated so and so, comma, the Learned Family Court has held that the petitioner herein, that is the respondent, sole respondent herein, is entitled to monthly maintenance amount of rupees 8,000 with effect from the date of filing of the case. Post of the family court has further directed the opposite party herein, that is the petitioner herein, to deposit the arrear maintenance allowance within a period of 6 months from 18/8/2025. First of, para Mr. Das, Learned Counsel for the petition, has submitted that. Where is your statement
Lordship,
that your salary has been reduced?
yes, Lordship, my salary has been reduced. It is annexure M, Lordship, page 173 to 178.
173 is a picture.
Oh, Lordship, it's my mistake, Lordship.
173, all these are
Yes, Lordship,
pictures.
Lordship. Page, annexure, Lordship, L, page 171 to 172. Lordship, got it? Annexure L, page 171 and 172. My salary has been reflected, that has been come down, deducted to 15,000. Out of 15,000, I am paying to my physiotherapist every month 9,000. That document has been issued by the concerned physiotherapist, which has already been annexed as
Submitted it after the judgment dated 18/8/2025, comma. The salary of the petitioner who has been serving as senior accounts executive in a private limited company, who was serving as, comma, has been demoted to the position of assistant accounts executive on and from 10/10/2025 via the demotion letter dated 8/10/2025 within bracket page 171, and as a result, comma, his salary has been reduced substantially. Poster. On perusal of the demotion letter, comma, it is noticed that the petitioner is shown to be demoted due to his poor performance. Poster. Para. During the course of the proceedings of FC criminal number 354/2021, comma, the petitioner himself had admitted that his salary was rupees 32,000. Poster. Before that, Mr. Das has further submitted that in view of his demotion, comma, the petitioner is not in a position to deposit the entire area maintenance amount allowance since 18/8 or since the filing of the petition. Poster. And the area maintenance allowance would be around 3 lakh. Poster. It will end you. Issue notice returnable on so and so date.
28-1.
Lordship,
The petitioner shall take steps for service of notice. The respondent number are sole respondent by speed within 3 working days from today. Stop. Para. Before that, before it, now submitted, the petitioner is a physically disabled person, and as per the disability certificate issued on 29/7/2021, comma, a petitioner has 65% permanent disability in relation to all his 4 limbs. Full stop. Para. Having considered, having heard the learned counsel for the interim prayer, comma, taking into consideration the facts projected in this criminal revision petition, comma, deems it proper to direct the petitioner to deposit 50% of the area maintenance allowance as directed by the judgment dated 18/8/2025 of the Family Court within the period directed by the Family Court, apart from depositing the current maintenance amount till the returnable date.
Said, Your Honor.
50% you deposit as per within the period. Area maintenance allowance, 50% you deposit as per the direction.
50%.
Within the same period, 6 months,
50%.
50%.
Highly obliged.
Area maintenance
Highly
plus current,
Highly
continue
Highly
with 8,000.
highly.
Item 2.
Complainant Babul Sarkar, Chief Judicial Magistrate. Accused. Yes, Mr. Goswami. Who is the petitioner here?
No one is representing my, nothing is there.
Babul
Babul
Sarkar,
is the petitioner, my lord.
appeal against acquittal.
Appeal against acquittal.
In a, let us see the judgment.
Lordship.
Babul Sarkar, he was the informant.
Yes, my-
So he was wrongfully restrained. So he is the victim.
he is the victim, my lord.
Then judgment is passed by CGM.
EGM.
So proviso to
P72 earlier.
P72,
Earlier.
now also same. So appeal lies before
Yes,
without leave.
without leave.
So this is not maintainable.
No, my lord. Nowadays leave.
Hmm. Who is the
P72.
counsel?
Nobody is representing me.
Okay. We put it tomorrow so that
Okay.
limitation.
Lordship.
Is survived.
Yes, yes.
Okay.
If
Mr.
there is
MP
any
Goswami,
vocal-
there is no representation on behalf of the petitioner, today on call. Post of. From the Okalanama annexed to the petition, it is noticed that the petition is filed through Mr. Istiak Alam and Mr. E. Sheikh SK, Learned Council, whose names are not reflected in the cause list. Also, Mr. MP Goswami, Learned Council, additional public prosecutor has submitted that when the remedy of appeal is available to the petitioners, this criminal revision petition is not
Lord.
maintainable. Post of. Para, as the office to list the case tomorrow,
Lordship.
reflecting the name of Mr. Ishtiaq Alam and Mr. T. Sheikh SK as the learned counsel for the petitioner in the cost list.
Item 3.
May it please the Lordship.
Hmm.
Now, here the petitioner challenges his conviction, my lord. Both the courts-
Conviction and affirmed by appellate court.
my lord. That's what my. I have filed an extra, my lord, additional IA for my bail, my lord. And the grounds are there, my lord. There are grounds, the signature, number one is, my lord, the complainant claiming to be a partner of the partnership firm, my lord, has come forward without any authorization by the other partners of that
The
partnership
check
firm.
was issued in whose name?
Check was issued in the name of the firm.
In the name of the firm.
Firm.
That is a very feeble plea now.
Not few, my lord.
Then
My lord,
next,
I have
next.
my lord, the signature in the check, issuing person's signature is not exhibited. The signature, my lord.
Have you disputed?
Yes, my lord, I have denied. My case is of denial, my lord. I have not.
Let's see.
My lord.
Let us see. Minimum 20%. We can go up more than that. Let us see then. Did you reply to the notice? Did you reply to the
No,
demand notice?
No. No, man.
No. So presumption again inference starts from that
My
point.
lord. My lord.
Let us see the evidence.
Can you do this? What is it?
Page 19. Let us see the complaint first. Oh, this is evidence.
This is a 145, my lord.
This is Mukul Sharma, proprietor.
This is 145.
Who is the maybe page 19.
Page 19.
He says proprietor.
He says proprietor, he gives a partnership agreement, man. Partnership, see, your lordship will kindly see.
Investment cum partner.
The partnership agreement dated 5/3 so-and-so is filed by me as complaint document number, which is agreement. And my lord, from the agreement, we came to know that his share is only 49%, not even 50-50.
That does
And
not,
there is no
that does not
authorization from the
affect-
other partner, man.
that does not affect.
My lord, that authorization is important in view of section 69, which is not only applicable to only civil liabilities. It is also been held by the court that it is also applicable in criminal cases, man. Of the Partnership Act, 69 of the Partnership Act.
Is the check a part of the?
No, my lord, I can put it, I have this.
Is it no in the memo of revision petition?
No, my lord. My lord, I can.
I have filed this case.
can do.
A case.
Lordship, we can-
Applied.
There is a copy of the check and then present the check and then return memo. My lord. Your lordship may, my lord, come to paragraph 6 at page 20, my lord. Paragraph 6 at page 20 of his deposition. He had exhibited the check as document number 16, but he didn't exhibit the signature.
When the check itself says Bipul Chandra Das, it has, and it bears a signature and it has been cleared.
No, that require.
This is too.
No, that presumption shifts, my lord. If it
No,
is not,
no,
my lord,
no, sir.
my lord, if it is not proven
If you
by
want
him,
to decide it today,
no, my lord. That is correct, my lord.
and who are you?
And the third issue, my lord,
Who are you?
my lord, I am, my lord,
Your
Bipul Chandra,
capacity?
Bipul Chandra Das.
Your capacity, supply, approach,
I
supply,
used to take diesel from him, my lord. That is the case.
diesel from
to
him.
Purchase diesel, my lord.
Where is the complaint?
Complaint.
Complaint Annexure 1, my lord.
Para
Yeah.
5 and 6, your lordship may see, page 20.
So you are businessman come government contractor come order supplier.
My lord.
So you don't deny your position. Because people are
I can't, my lord. I have not.
petitioner and respondent are coming that they are below poverty line after issuing 9 lakh, 10 lakh check. So that is why I am asking.
I have not said, my lord. I have not said I am a petty businessman. I have not said that. And the complainant himself says that I paid back quite a substantial amount, my lord.
Yes.
Yes, ma'am.
So that is why
That is why.
you don't take that plea that I am below poverty line.
My lord. Now, my lord, he also claims that a check was presented before the Borpatha branch, my lord. Now, if your lordship, I have placed that copy, my lord, that will show that Sorupatha branch is mentioned there. And that bit of information not explained by him. Your lordship will kindly see.
First check is bounced or dishonored on what ground?
Insufficient fund.
Insufficient fund. And check, did you deny your signature in the?
Yes, my lord.
You deny?
Yes, yes.
Let us see the cross.
What is it? Huh?
I have experience.
PW3, page 30. Hmm. কোনখিনি? Before this court on receiving summon.
No, not familiar.
No, signature under objection. Check was executed
Registered.
of Borpatha branch. Page 30, my lord. Wait. শোনো, এখানে কোথাও। এগুলো তো- Outro. Outro. Wait.
Heard Mr. B.D. Goswami, learned counsel for the petition, and Mr. M.P. Goswami, learned additional public prosecutor for the respondent number 1, State of Assam. Post of this criminal revision petition is directed against a judgment dated 19/9/2025, passed by the Court of Sessions Judge Golaghat, within brackets, the appellate court, in criminal appeal number 26/2024, whereby the appellate court has affirmed a judgment,
Dated 11/7/24.
an order dated 11/7/2024, passed by the Court of Sub-Divisional Judicial Magistrate M. Dhonsiri Hurupathar Golaghat, case 33, trial court, in complaint petition number 06/2022, while dismissing the appeal, post of. By the judgment, an order dated 11/7/2024, the land trial court, after finding the petitioner, who was arraigned as the accused, guilty of the offense under section 138 of the Negotiable Instrument Act 1881 as amended, convicted him accordingly. Full stop. The petitioner has been sentenced to undergo simple imprisonment of 6 months and to pay a fine of rupees 9 lakh to the complainant. That's respondent number 2. On the basis of the amount of the, as the, full stop, para. The respondent number 2, as the complainant, has instituted complaint petition number 06/2022. After dishonor of a check for an amount of rupees 5 lakh, issued, purported allegedly issued by the petitioner hearing, post of issue notice returnable on so and so.
30.
As Mr. Goswami has appeared accepted, as per number 1, formal. The petitioner shall take steps for service of notice upon the respondent number 2. As complained by speed post within 3 working days from today. Uh, the trial court records PCR as well as the appellate court records be called for. Heard Mr. B.D. Goswami, learned counsel for the applicant as revision petitioner, and Mr. M.P. Goswami, learned additional public prosecutor for the opposite party, that's respondent number 1, State of Assam. Post of the instant application is preferred seeking suspension of sentence, suspension of execution of the sentence passed against the applicant revision petitioner. Post of the applicant revision petitioner has preferred the accompanying criminal revision petition against a judgment dated
1999.
19/9/2025 passed by the Court of Sessions, Golaghat Appellate Court in Criminal Appeal number 26/2024, by the Appellate Court, while dismissing the appeal preferred by the applicant as revision petitioner, has affirmed a judgment and order dated so and so, passed by the court of so and so, in complaint petition number so and so, post of by the judgment and order dated so and so, the trial court, post of heard the learned counsel for the Mr. Goswami has submitted that the complainant instituted the complaint is in the name of Messrs. Arunodaya Enterprise, wherein he is stated to be a partner. Post of it is submitted that the complainant did not exhibit any authorization letter to institute the complaint in the name of Messrs. Arunodaya Enterprise. Post of he has further submitted that in the dishonor check, the signature of the applicant revision petitioner was not exhibited during the trial. Post of yes. What other matter? What other submission?
My lord, he claimed that the check was presented before the Sorpota branch. But the document, the check shows that it was returned by the Sorpota branch. That is not there.
But the bank official has been
The Sorpota branch manager was not examined.
fact of the matter is it is dishonored. Okay, I'll record
My lord.
so that it should be region order. He has further submitted that the check was
He claimed that he presented it before
the
the Sorpota.
complainant claimed that he deposited the check for collection at Borpatra branch
Of SBI.
of SBI, whereas the check was, in fact, presented for collection in the Horupatha branch of the SBI.
And return memo was also issued from this Sorupata.
Full stop. And the return memo was issued from the Horupatha
No, Horupata.
Horupatha branch of the SBI. Full stop. Para. The above submissions advanced on behalf of the applicant revision petitioner have been considered for the findings recorded by the trial court as well as by the appellate court. Full stop. The check so dishonored was contains the name of the petitioner. Our check dishonored was issued from checkbook issued in favor of the petitioner wherein his name was reflected. So further, the check was issued in the name of the firm Messrs. Owner Enterprise and the complaint petition. Complaint was instituted in the name of Messrs. Owner Enterprise, wherein the complainant has projected himself as one of the partners. Full stop. Like presentation of check. It is the collection or return of the check to the Troy, which is material, and privacy, presentation of a check can be made. Presentation of a check, like the check in hand, like the dishonored check in the case in hand, which is payable at par at all branches, is insignificant.
Madam, may I just?
Full stop.
Madam,
Prima facie.
yes,
I have said privacy.
Yes, privacy. Madam, Horupata branch manager was not examined, madam. That's what I wanted.
That is a matter to be examined in the hearing. We are not hearing it.
Yes.
We are admitting it on.
Right.
Para. From the materials on record, from the judgments of the trial court, as well as the appellate court, it is noticed that Messrs. Orondo Enterprise deals in selling of diesel, petrol, lubricants, etc. And the applicant revision petitioner is a businessman, government contractor, and order supplier. Full stop. From a number of documents reflecting transactions between the two sides were exhibited during the course of the trial. So it further emerges that towards payment, the applicant revision petitioner as per the testimony of the complainant, the applicant petitioner had paid sums of rupees 58 lakh, 57,556
556.
and rupees 13 lakh 35,800 against a liability of rupees 79 lakh 23,334.86. First off, in the above facts and circumstances, this court is of the view that the operation of the impugn judgment of the appellate court shall remain suspended, subject to deposit of 20% of the fine amount within a period of 60 days of a deposit of so and so by the applicant revision petition within a period of 60 days from today. And he has to go on bail
Yes, my lord. As per the,
because imprisonment is there.
yes, as per the my
Uh,
criminal appeal, my lord. Appellate section, my lord. He has to.
First of, it is further ordered that the applicant revision petition shall be allowed
Oh,
to
bail out
go on bail. First of, the applicant revision petitioner is to place the deposit receipt on the next, within immediately after expiry of 60 days before this court for continuation of the interim order.
মাছ হবে না।
No, loss. But
Yes.
no, my lord, regarding the.
Oh, bail,
that-
bail, 5,000.
No, I am not considered.
No, he has to go on bail.
Yeah, he has perhaps in previous bill.
And I am on previous bill actually.
Then again has to.
Okay. It will be, very. As the petitioner has submitted that. Who is granted?
The appellate court.
But
Appellate court has granted.
appellate court, my lord, there is no such.
Till the time of filing this, my lord. The time given by the appellate court, so till that point of time, my lord, I am on bail.
Yes, what to do?
কিমান সময় দিছিলে? 3 মাহ দিছিলে।
Trial court or appellate court?
My lord, because in the appeal, my lord, I have not found that, my lord.
Hmm.
What is it?
Appellate আছে? নাই।
The
Only-
petition is further
only the-
allowed
No,
to
trial-
go on, fresh bail.
Yes,
Fresh
bill,
bail,
I
lordship,
think
may-
Fresh bail.
fresh bill.
Fresh bail, my lord.
With one security of the like amount to the satisfaction of the trial court.
মাছ হবে।
Will modify. 5,000.
Item 5.
May I please, Your Lordship? My lord, in this case, my lord, we are challenging the proceeding of a check bounce case, my lord. That is, Your Lordship will find it in page number 11, my lord.
Khan, and Judy Becker. Yes, what is the ground?
My lord, ground is, my lord, section 141 of the NAG, my lord. As per 141 of the NAG, my lord, the company, my lord, which is dealing with the complainant, was not made a party in this case, my lord. Because, my lord, so for 141, my lord, I am reading, my lord. If the person committing offense under section 138 is a company, every person who at the time of the offense was committed was in charge of, was responsible to the company for the conduct of the business as
Now
well.
first come to the check.
Check, my lord, check,
The check is what? Below Noyanjiti Deka, what is written?
my lord, here, as per para number 2, my lord, of the
No,
complaint.
no, come to page 19.
Yes,
In the check, this is illegible for me. So you might be having a
No, no,
legible copy.
no, Noyanjiti,
What is written below it?
no, it's the signature only, madam.
No, something is written below it, sir. Noyan Juditeka in type. Thereafter, your signature. Below that. Page 19.
Actually, it should be page number 24 actually, because,
Where is the check, sir?
yes, madam, we'll check.
What is written? My photocopy is very illegible.
Never mind. I cannot make out.
See, there is subtle difference. Rent agreement
With the company,
with a company, right?
yes, ma'am.
He says that
Page
she
11,
let out to Kamaya Engineering Services Private Limited, right?
yes, ma'am.
And you paid a part of the amount, but how much?
5
5 lakh?
5 lakh 83,000.
83,000 something. Right.
Yes, ma'am.
This case is of 2021. At what stage it is?
But now it is in the stage of cross-examination of the complainant. Cross-examination. Next date is the-
Cross-examination of the complainant.
Yes, ma'am. 9/1/26.
Huh. Tell me what is written below your name.
And below.
And what is this Ramaya?
Amaya
It is a
Engineering,
proprietorship firm
hello.
or private limited company
It is private limited
where
company.
you have stated?
In para number 2 of the annexer 1, my lord. Para number 2 of annexer 1.
Para number 2. No, your petition.
Oh, yeah, yes.
Where is your environment? Many times somebody names his firm like Messer so-and-so International Limited, but it turns out to be a proprietorship firm. Where is your environment, sir? To take that plea that Kamaya Engineering Private Services Limited is a incorporated company.
And one more minute in the explanation
Please
part.
tell me,
yes.
I have asked a
Yes, sir.
query.
Yes, ma'am.
I think
In
it is your
para
duty
number-
to respond.
Yes, ma'am. Para number 8, my lord.
Para number 8.
The respondent did not make Kamaya Engineering Service Limited a party, public accused in the instant case. The complainant respondent herself said in
But
the check was issued.
Where is the statement? This is an incorporated company under the Companies Act. You bring in 141. Where is your statement?
My lord, we have that document, my lord. We have that document. That was,
So I need a statement only on oath.
and we'll file additional affidavit, my lord, in this regard, my lord.
See, Mr. There is subtle difference. Many times, Mr. Messrs. MP Goswami International Limited. But it turns out to be a proprietorship firm. Right? Many times these kind of names are written. But it is a proprietorship firm or partnership firm. If it is an incorporated company, right? And you only as an authorized signatory had issued a check, then complaint might not be maintainable without arraying the company as a party. But if it turns out to be a partnership firm or proprietorship firm, and you have issued the check, not as an authorized signatory. That is why I am asking many times that what is written below your name.
Actually, director is different.
Huh?
Director of the company. is
No,
different.
I am not. Let us have your certificate copy.
Certificate, my lord,
No, that, check.
check.
You could not understand.
Yes, I asked this.
But if it is issued from your private account, then no, not required. The company is not required.
No, it is from my private account.
Private,
My personal account.
then
Personal account.
your case.
My lord, personal account because personal.
If it is a personal account, then
Well, only thing, well, only thing is,
the law is settled.
no, only thing is.
Law
that,
is
my lord,
settled. I don't have the judgment.
I have
set
got,
of
I have got the
judgments.
judgment, my lord.
If it is from your personal account, then no. We do not entertain unnecessary.
Page number, para number. Yeah, my only thing is that, my lord, the liability belong to the company, my lord.
But still, no. When liability is of the company, you are a director or somebody,
According to the vice president.
director, vice president, whatever, but you issued the check from your personal account,
Personal account.
then the litigation is maintainable. Right? But if you had issued the check as an authorized signatory of the company, then without implementing the company, the complaint is not maintainable. That is the law. Tomorrow I'll find out the judgment. I have read. No point.
Yes, on impacts.
Huh?
Impacts,
Impacts. It is there.
impacts, yeah.
এই এই দুটা যে আছে চাওঁ এই দুটা যে আছে চাওঁ Anita Hada is for authorized signatory or director. There are specific tomorrow. We'll
Yes, ma'am.
get the judgment.
Yeah.
In his personal capacity, then
No,
Yeah.
actually, as per their own version, my lord. Actually, it is their own
no,
version.
you get your
No, man.
get the instruction from your client.
No, my lord, only I'm reading the complaint petition, my lord. Complaint petition, my lord, kindly see. That is why I have come, my lord. Complaint petition, annex 1, page 11, my lord. Number 2, that the complainant is the owner of a commercial complex situated at near so-and-so place, Dibrugarh. And she let out the commercial complex to the accused, who is running the institute under the name and style of Kamaya Engineering Service Limited as vice president.
Hmm.
Only this thing, my lord. That
No,
is
para 3.
para 3.
Para 3.
Para 3.
Maybe the complaint is clever because the check was issued in your personal capacity. That is why she did not err. That question I asked is very specific, right? If the account is, check was issued from your personal account, law is different. If as an authorized signatory, then law is different. Please, I guess tomorrow. Slight difference in facts brings whole lot of difference. Find out.
Yes.
You can still make out the case. Next.
Item 6.
Lordship, this is an application under 528 of BNSS. This is an application under 528 of BNSS for setting aside the order dated 27/10/25.
Application for series of recalling impugn order 2710.
Yes. My custody,
2710 is case number so and so, case number so and so.
Item 6.
Jimma custody. Mobile,
yes, mobile and some other important documents, Lordship.
several other, but there are
Aadhaar
several
card.
others.
Aadhaar card,
We just see our list.
Not annex.
this release is not an.
Page 10 is the impugn order, my lord.
Para 6 of the impugn order.
Yes.
Read. Read, madam.
Lordship, the record reveals that the case is registered under section 10, 13 of APA, along with sections of
Next line is
DNS. The
important.
prayer made in the petition reveals that the petitioner has prayed only for the mobile handset, and the IO has objection with regard to giving Zimma of the mobile phone to the petitioner.
So you prayed for only mobile. Now you are saying everything I have.
In our application, we made also for the documents.
Without the document, how can I cannot go into that trial court and look into the records. Third, we are only confined to mobile set now.
Mobile.
If you can bring something else, that is a different thing. Miss,
Amen, Konyak Lordship. Amen.
Council for the petition. Well, coming to the High Court, you should have filed your petition, Zimma petition as part of the record and a seizure memo.
Lordship, in the
Minimum, that is minimum. Right. We are sitting in revision or as an appellate court.
in the Caesar list also, Lordship, it's mentioned only mobile phone.
We don't know, madam.
Mm.
And Mr. M.P. Goswami, learned additional public prosecutor for the respondent. State, full stop. Issue notice returnable on so and so. A learned additional public prosecutor shall obtain a report from the IO as regards necessity of keeping the mobile phone of the mobile phone bearing IMEI number 860322052889 70/43 is not silo with SIM bearing number so and so. This order is different.
In page 11, madam. Yes, ma'am.
Page 11, first para.
First.
But para 6 is different.
Praying for Zimma prayer.
Without the petition, how can we say? Without the seizure list?
Yes.
Only we will confine to mobile. On the next date of listing.
28-1.
Obliged.
Item 7.
Lordship, here I have challenge the impugn affair as well as charge sheet and the
Impugn
subsequent
FIR.
proceeding.
What is impugn FIR? Let us see.
Lordship, that is page 11, Lordship.
Page 11.
Yes.
What is 126, Mr. Goswami?
Lordship,
BNS?
BNS. I'm sorry, I'm not. 126. Lordship, wrongful restraint. Indian Penal 339. One 126(2) wrongful restraint, 127(2) also wrongful restraint. That's all.
Yes,
Yes, Lordship.
you want quashing of FIR and charge sheet.
Yes, Lord.
On what ground?
Lordship, because this affair is lost with an ulterior motive, because out of same incident, as the petition number 2, he lost earlier contact and one affair I have annexed there, Lord. And that is start page 24, Lordship. This affair has been lost, this affair has been registered as Hilsor PS case number 499, the present one, and my case has been registered as 498 on the same day, Lordship. Page 24.
Then it resulted into charge sheet.
Result in charge sheet. Yes.
Huh?
Page 20 is the.
No, your FIR
Lordship, the affair which I have.
lodged by you.
Yes, page 24.
This is FIR.
Yes.
Then whether it resulted into a charge sheet.
Lordship, but it was registered.
Registered on the same
Yes.
date,
Yes.
right?
Yes.
Now, the other case lodged by the against you
Yes, Lordship.
was charge sheeted immediately after 18 days,
Yes, Lordship.
right?
Yes.
Now it is about more than 7 months.
Yes.
Whether your case has been charge sheeted.
Lordship, in this case, I have no specific
No.
information.
And the victim, the informant,
Yes.
she had injuries on her person.
No, Lordship, this, Lordship.
No is different thing. That is a matter of appreciation, not a case of quashing, madam.
No, Lordship.
No, I am dismissing it. No part.
No, Lordship, kindly see, Lordship, one thing.
You
Lordship.
come with better particulars.
No, Lordship, at this notice may be issued, Lordship.
No notice. No point.
No, Lordship, kindly see,
No.
Lordship.
Hard, Mr.
No, Lordship, let me submit.
I am
your
not
Lordship,
satisfied.
dismiss it,
Not
Lordship,
satisfied
kindly-
means not satisfied.
Lordship, I am.
Aged Ahmed.
Lordship, just record my submission.
Cross
and
case.
dismiss.
It is a cross case. It will be tried by the trial court.
Lordship, just record my.
This petition cannot be quashed.
Yes.
The FIR and other
Yes.
charge sheet
Yes, Lord.
cannot be quashed just because you lodged a cross case,
No, Lordship.
cross
because-
FIR.
Lordship, as per Bhajanlal's case, Lordship, when Lordship, it
You,
has been.
okay, you want to say me Bhajanlal, okay?
Yes, Lordship, with ulterior motive, Lordship.
Which para of Bhajanlal? Para number?
Lordship,
Don't look at. Citation.
Lordship, 1992, one SC Supply 335.
PT5.
Yes, Lord.
What says? There are 6 grounds.
Yes, Lord.
Which one?
Lordship, I think third one, Lordship.
Hmm?
Lordship, there was an ulterior motive, Lordship. Lordship, it, my humble.
Ulterior motive cannot be taken from the FIR. Certain more materials are required. This is the only FIR. This is the only FIR which is filed by you.
Yes, Lordship.
You are seeking quashing of the cross case.
Yes.
Heard Mr. Aged Ahmed, learned counsel for the petitioner, and Mr. M. P. Goswami, learned additional public prosecutor to the respondent state. Full stop. Para. The petitioner to this criminal petition filed under section 528 Bharatiya Nagarik Huraka Honida 2023 has sought quashing and setting aside of a first information report registered, comma, lodged by the respondent number 2 as the informant, comma, before the officer in charge, Silsor Hodor Police Station on 12/5/2025 and a charge sheet bearing charge sheet number 361/2025 dated 35/2025 submitted in connection submitted after completion of investigation into the affair, comma.
To withdraw lordship to file and better petition.
It's up to you. This part, just because the other has been charge sheeted, your case has not been charge sheeted.
Yes, lordship.
You come up that I have a cross case.
Yes.
Mr. Ajit Ahmed, learning counsel for the petitioner has submitted that the petitioners want to withdraw the petition with liberty to stop. Mr.
Yes.
MP Goswami. Response number 1, present. In view of the above submission made by Mr. Ahmed, the criminal petition is dismissed on withdrawal, comma, with liberty as paid for.
Yes. Otherwise, page 14 is very much clear, my lord. All
I have seen it.
much.
Almost. This matter may be taken up at 2 p.m. 2 p.m. Lord.
No 2 p.m. after motion and all, as per the convenience of the court. Next.
I didn't know.
Yes.
My lord, the petitioner praying to quash the order. Page 51, my lord.
Page.
Page 51, my lord. The family court of
51.
Dhubri.
This is what, 125?
Yes, my lord. 125 order passed
Sanibala
against the
Roy.
present petitioner.
Saranjit Pradhani.
My lord,
Okay.
hereby directed that the.
What is the
petitioner
operative
respondent is the
part?
wife.
What is the operative part?
My lord,
Directed 15,000.
yes, 60, my lord, 60.
15,000.
Yes, my lord, 15,000. In fact, my lord, it was only a agreement between the present petitioner and the respondent, my lord. An agreement validity was 6 months. And that time, my lord, the present petitioner,
Agreement? What kind of agreement?
there was a marriage agreement, my lord.
Huh?
On the basis of marriage agreement, she filed this.
Being validity is 6 months. Thereafter it lapses.
Yes, my lord.
It is also lapses.
Yes, my lord. And thereafter, the civil court, my lord, declared that it is not the, my lord, valid agreement.
Let us see the civil court judgment.
Civil court judgment, my lord, I have annexed, my lord. That is the finding, my lord, here. The page 43, my lord. Page 43, my lord, the relevant portion.
Page 40. This is
43.
title suit.
Yes, my lord, title shoot, my lord.
You instituted.
I have filed the title shoot, my lord, and it is.
Against the lady.
Yes, my lord. Already is,
Okay,
already spent its
decree
course.
of contest, marriage agreement.
No marriage was solemnized. And expiry order is passed by the family court, my lord. Present petitioner is a BSF personnel.
Yeah,
Yes, my lord.
title suit. Who is the operative part
Page
of the title suit
Page
judgment?
55, my lord.
43, my lord.
Reason
1 minute. Marriage agreement dated as already spent. Okay. So there is no marriage.
Yes, my lord.
Okay. Now, when the judgment was delivered?
My lord, it was delivered on, my lord, 10 February 2025, my lord, this year. And the family court, my lord, passed the order.
It was
That was on-
125 was instituted in 2022.
22, my lord.
Okay.
because it was pending.
Then it was a contested one,
Yes, my lord.
contested one. Okay.
The suit is contested, my lord, but the family court's order, ex parte order in favor of the respondent.
Ex parte,
Ex
that
parte
was
order.
9/5/2022.
Yes, my lord. Yes, 52.
So then how you have, what kind of petition is this?
My lord, I have trying to quash the family court's order
No, it
because
was of 2022,
2022, my lord, because
3.5 years back.
yes, my lord. That time, my lord.
Where is the question of limitation? There is no question of limitation.
No, my lord,
Just
for-
in the garb of 528. How can it be?
my lord, in quashing petition, my lord, because
No. In the garb of crossing,
that time, my
you
lord.
cannot avoid the period of limitation.
My lord, that time the civil suit was pending. Civil suit was not decided.
So you take your own decision. This
No.
criminal petition is beyond limitation. It ought to have been when the statute prescribes,
My lord,
when the statute prescribes a revision.
my lord, quashing, my lord. I have come quashing, my lord, because
But
cause of action.
This is what court? Principal judge.
Principal
Family
judge.
Court Act.
Then-
Family Court Act.
I was
It
waiting.
is governed by Family Court Act.
Yes, my lord. I was waiting for
So, appeal line
result
a
of
division-
title suit, my lord.
Appeal line and revision bench.
Or revision lies before this court.
Or
Revision.
Revision lies this court.
Specific, no why 482?
Yes. my lord.
When the proceeding is before family court,
Yes, my lord.
right, Mr. Anuddin, then provisions of section 19 of the Family Court Act is applicable, overriding CRPC.
Right.
Save as provided in subsection 2 and notwithstanding anything in the Code of Criminal Procedure or in any other law, an appeal shall lie from every judgment or order not being an interlocutory order of a family court to the High Court, both on facts and law. Next, no appeal shall lie from a decree or order by the family court with the consent of the parties. Then, provided that nothing in this subsection shall apply to any appeal pending before High Court High Court may on its own motion or others call for and examine the records of any proceeding in which family court situated under chapter 9 for the purpose of satisfying itself as to the correctness, legality, or propriety. These three words appear where? 397 and 401.
Revision.
Meaning thereby revision. So you cannot obviate, bypass by filing it at 525, 528.
I would do.
Bar by limitation.
My lord, I will do, my lord. I want to do.
And another fact is that, my lord, page 55, my lord. By admitting, my lord, he has, my lord, paid a my lord, amount of.
This is 528, and if it is to be converted into a revision petition, he has to file a petition for condonation of degree.
Continuation, and half of the, my lord, in fact, my lord, he has admitted my position is there, my lord, half of the amount already paid.
No, that means I was paying.
We are not into merit.
That time it was pending the civil suit. I was waiting for result of that.
Mister, you think it over.
My lord,
Both the court have concurrent jurisdiction, session judge as well as high court
Yes, my
for
lord.
revision. Oh, sorry, it is family court, now high court.
Yes.
Only high court,
Only high court.
only high court.
Yes, my lord.
But that is by criminal revision petition. If you want to satisfy yourself, you
Yes,
get
ma'am.
yourself
I have
satisfied.
satisfied, my lord. Yes, my lord. So
Then
I want to do
come back
liberty
and-
to file a fresh, my lord.
Second half,
With liberty to file a fresh, my lord.
sure,
Yes,
but not this way.
yes, my lord.
Heard Mr. Anuddin, learned counsel for the petitioner, and Mr.
MP.
MP Goswami, learned additional public prosecutor for the state. Respondent number 1, state first of Mr. Uddin has submitted that the criminal petition under section 528 CRPC has been preferred against an order of the learned against an order dated 9/5/2022 passed by the Court of Principal Judge, Family Court Dhubri,
Family Court Dhubri.
in FC criminal case number
10/22.
2022, which was registered on the basis of an application preferred by the respondent number 2 as the petitioner under section 125 CRPC. Full stop. He has submitted that as in view of the provisions contained in section 19 of the Family Courts Act 1984, more particularly, subsection 4 thereof, the petitioner wants to withdraw the writ petition in order to avail appropriate remedy. So, in view of the above submission made by Mr. Uddin, this criminal petition is dismissed, with liberty as prayed for.
I'm Basu.
Item 10.
Yes.
So I'm taking enforcement of the order dated
Criminal
9/25.
petition.
Whereby cognizance is taken under section, my lord.
What is the impugn order?
Is it page 28?
Page
28.
22.
8.
28. Oh, just it. Case record is received with FIR, CGL is Kitchener.
It's basically an.
What is 196? I don't know nowadays. Huh?
To, my lord, create communal tension between two communities, man.
299?
This, all these three my lord, sections are related to each other. On
I'm
the
not very
same point.
familiar with this
Lordship.
BNS.
No,
BNS.
196.
299.
Promoting
Delivered
enmity
and
between
this year's.
classes in the place of worship.
Okay, earlier 295. Religious feelings. Then 196 2. 150. 352. 350. Okay.
Is basically in the
Ah.
place of worship or any other assembly engaged in the performance of religious worship. 196.
Now what is the
Now the
case about?
allegation is that FIR has been lost by one of the member of this corporation.
What is the FIR?
Heavy VP, my lord, at page 25. My lord, 15.
FIR?
FIR is at page 15. Not a school of a particular religion, my lord. All the, my lord, the students are belonging to different, my lord, communities and, my lord, religion.
Well, you should notice scan copies.
Conduct is not good, madam.
This is not.
No.
It did not happen.
No.
I have
Yeah.
given the photograph, Lordship, may kindly see the page 29, the bathroom photograph I have given, which says the goods have been, the tiles was destroyed, so they could not seize it. But this is the wall photograph I have given at page 29 and also page 30. These are under renovation. It was never there, my lord. The whole thing is that, my lord, there used to be, my lord, demanding money from time to time, which, my lord, having been refused, my lord, this FIR culminated, my lord, with this sections. Police did not, my lord, have any, even in the taken a, my lord, audiovisual report, my lord, which is mandatory as per the new, my lord, BNSS 105. my lord.
Hmm?
Now, in case of search or seizure, my lord, under the new BNSS 105 has been incorporated, whereby, my lord, recording of the audiovisual is a must. That is not done. And the photographs I have given, my lord, your lordship will see that it's.
Which photograph?
Page 29. They said allegation is in the inside of the bathroom wall.
No,
We have affixed one, my lord.
this photograph, now Supreme Court has said that to rebut what kind of unimpeachable materials. Laid down the guidelines now. In Justice Party versus judgment. Don't
Nothing is
bother
wrong.
right.
Should have recorded, my lord. They should have, my lord, they recorded the, my lord, at least.
Issue
visual-
notice at this stage.
Gotcha.
Scan copy will.
Yes.
Charge sheet has been submitted, right?
Yes, is submitted, my lord.
Okay, then scan copy. Third, Mr. P.J. Soikal, and senior counsel listed by Mr. Listed by
M. Rahman, man.
M. Rahman, learned counsel for the petitioner. And petitioner, and Mr. M.P. Goswami, learned additional public prosecutor for the respondent. State. This, who is the complainant?
Complainant,
Is it not required otherwise? Any
Well,
idea?
of course.
It's
Already
a
charged it.
private complaint, my lord.
Private
Perhaps it has to be.
This
Yeah.
criminal petition under 528 PNSS is P5 seeking quashing of an order dated 2/9/2025 passed by the Court of Subdivision Judicial Magistrate S. Gwalpara in PRC case number 501/2025, whereby the trial court has taken cognizance of the offenses under sections fileable BNSS and issued process against the petitioners for their appearance to stand in the trial. Because the petitioner has also sought setting aside and quashing of charge sheet number 85/2025 dated 29/6/2025, submitted after investigation into Gwalpara Police Station case number 106/2025, registered at the instance of an informant.
One Jitumani Sharma.
One, Jitumoni. One instance of one
Jitumani.
private individual. As an office bearer of an organization. First of Mr. Goswami, learned counsel, additional public prosecutor has submitted that the informant has not been implemented as a party respondent in the instant criminal petition. First up, issue notice returnable and so.
28.
Having regard to the projections made in this criminal petition, let the scan copies of the TCR within bracket PRC case number 501/2025 be called for. Post of a pair for interim relief is kept open for consideration on the returnable date.
28th January. Listener number one is a Hindu who is the principal of the school.
We do not know. We are not into that.
That's
Who is there?
No, the ingredients of this section are.
But it has a tendency and propensity.
Obliged.
My lord, may it please your lordship. My lord, at page number 27 is the FIR against me. I am a interior designer, my lord. And if you're, this is long FIR at page 27 against me, my lord. It is a
Accused.
counter blast against an FIR lodged by me. Earlier in
Let me read the FIR first.
Yes, my lord. May I read it?
petitioner. No, only an advance delivered. Petitioner, the state amount is. Let's check. Use with the farm in the name and style stated above. Stated above. As struck in. And therefore interior. Solicitor had entered in agreement with the petition for RCC building. Constituent count. 8 bedroom. The fees of 55 lakh. Yeah. Given. For the state amount on is given. Yes, where is your FIR?
My lord, my FIR is at page 34. This is prior to time, first in time, my lord.
Yes, Mr. Goswami. Transaction party is there, but does not look like that it is a case of cheating. He executed works of 4 lakh. Heard Mr. T.H. Hajurikal and counsel for the petitioner. And Mr. M.P. Goswami, the additional public prosecutor for the respondent number 1, state of Assam. Post of the petitioner has preferred the present in his petition under 528 Bharatiya Nagarik Surakha Amrita, seeking setting aside and quashing of a first information report, comma, lodged by the respondent number 2 as the informant, comma, which has been registered as North Lakhimpur Police Station case number 166/2025 for the offenses under section 316 within bracket 2 stroke 318 within bracket 4 stroke 3 within bracket 5 is 31 of the city of the BNS Bharatiya Nagorik Bharatiya Nyaya Honita BNS. So, in the FIR, in the FIR lodged, comma, the informant alleged commission of criminal breach of trust and cheating against the petitioner. Full stop. As per the FIR, comma, the petitioner was engaged, petitioner, comma, who is an interior designer by profession, comma, was engaged by the informant for design and interior works of a RCC building which is being constructed by the informant. Post stop. As part of the agreement, comma, the petitioner, sorry, the informant, petitioner was paid an advance amount to execute the works. Post stop. The informant has entirely alleged that after payment of a sum of rupees 19,25,000, the petitioner only executed works to the extent of rupees 4 lakh. Post stop. Subsequently, comma, another agreement was executed on 6/5/2025 in supersession of an earlier agreement whereby the contract amount was fixed at rupees
3 lakhs.
Full stop. Alleging that the petitioner did not execute the works as per the subsequent agreement dated 3/5/2025, comma, which was to be executed within a period of
2 months.
2 months.
Yes.
Comma, the petitioner has lost the, informant has lost the FIR. Post stop. Mr. Hazarika Pera, Learned Counsel for the petitioner, has submitted that at an earlier point of time, comma, the petitioner lodged an FIR against the informant on 9/5/2025, and the said FIR was registered as North Lakhimpur Police Station case number 167/2025 under section space 37 BNS. And the FIR lodged by the informant is a counterblast to the FIR lodged by the petitioner. Post of issue notice returnable on so and so date. The petition, as Mr. Goswami has appeared, accepted. Response number 1, the formal notice. The petition shall take stage for service of notice on the response number 2 by speed post within 3 working days from today. Para having regard to the contents of the 2 FIRs, comma, registered as so and so and as so and so, and the ingredients of the offenses of criminal breach of trust and cheating, comma, this court is of the considered view that the petitioner has made out a prima facie case for interim relief. So it is, comma, accordingly ordered that further proceedings, criminal proceedings pertaining to GR case number 446/2025, corresponding to North Lakhimpur Police Station, case number 166/2025, shall remain state till the returnable date.
3001.
I'm deeply obliged, my lord.
Item 14.
May I please, your lordship. My lord, I have filed this criminal petition to quash the FIR, that is page 13 of Gormur PS case in the district of Majuli. So here, lordship would see page 13.
Who is this petitioner?
Petitioner
What
is
is
one
his
of the
relation
accused.
with that Homobai committee?
Petitioner is the accused.
No. What is his relation with the cooperative
Yes,
society?
relation is that there was
Let
an
us read the
agreement.
FIR.
Lordship kindly see page 14,
Hmm.
the operative portion.
Said that the
With due respect, I beg to say that the aforementioned two persons that means one is
two persons.
Zakir Hussain and another is a Pradipta Kumar Das Samanto, page 13 below. So the aforementioned two persons through their secret sources and along with another accused named Zakir Hussain introduced himself before Majuli
agreement.
Gormur Samabay Samiti through this introduction. Accused number one very cleverly faith and Samabay Samiti as mentioned below and sign a written agreement. This is my case. There is an agreement between Majuli and the Gormur Samabay Samiti in the district of Majuli and the present petitioner and Samanto, who is the general manager. Now they say, now kindly see, page 14, second para. Let me see, go upwards. A written agreement, but number two accused subsequently violated the clauses of the agreement, unlawfully causing farmers believed to them per quintal lahi and sali pedi quintal an amount of as certified by the district agriculture officer. So here the agreement was that the accused would supply lahi and sali pedis, including some other non-PDS item, that is potato, onion, garlic, etc. So in violation of the relevant clause, they did not supply, and it is their
So
allegation.
you introduce yourself as what?
I am as the one of the coordinator of that. Lordship may kindly see.
Below, as mentioned below, signed a written
Kindly see
agreement.
page 19.
You executed the written agreement.
You means I and this
No,
someone.
not Mr. Mahmood. The petitioner.
Yes.
He executed an agreement
He along with
with the cooperative society.
Yeah, the cooperative society. Then this kindly see page 19, it will be clear. National Federation of Farmers Procurement Processing and Retailing Cooperatives of India Limited. So this is an
amount of
non-government organization.
account of each farmer against deposit ready. What is the content of the FIR? Whether it is the vernacular cannot be read.
Vernacular page 16.
Cannot be read.
But it is certified. It is certified copy.
Nakfof.
The FIR itself is not so clear.
I have not understood. Stored item. What is the second para? What is the meaning of second para?
Second para.
Page 14.
Meaning is this, my lord, the Gormur Somay Sumiti entered into an agreement with the present accused and accused number 2, that is Samanto, who is the general manager of the NECOF, that they would supply paddy, lahi, shali, etc. Rices to the Somay Sumiti. Now, Somay Sumiti says that they have not supplied proper quantity of those materials and thereby has caused a loss of rupees 37,850 was received in account of each farmer against depositing paddy only rupees 1,470. However, due to flood that affected Majuli, the farmers failed to provide the crops as promised. As promised, kindly see, there are the violation of both sides. During that period, NECOF, a government-affiliated organization, supplied onions, garlic, eggs, and potatoes to the Somay Samiti, but the Somay Samiti could not store the required quantity of supplies due to insufficient storage facilities. Among the stored items, approximately 500 plates of eggs, 150 quintals of onions, and 330 quintals of potatoes were stored in the Somay Samiti. The total cost of these supplies were 6,51,120.
Do you have you typed a copy of the source sheet?
Yes, I said I have
What is
an
the first type copy?
yes, that is type copy.
What is that?
22.
These are original copy. Have you typed it?
Original copy is typed and that is Xerox.
This is already illegible.
But what can we do when these certified copies we have brought?
No. If it is illegible, the petitioner should file a typed copy.
That may be given, but my lord, at present, my lord.
No, I have not understood. Your statement of so-and-so issued notice, branch manager requests in details of account number collectors on taken statement of. Present Zakir Hussain.
Now, our submission is, my lord, is that they had no proper facility to keep those materials which we have supplied. They kept here and there.
Amount deposited by cooperative society.
No, it was deposited to cooperative society by us.
But page 23, case has been investigated by DSP.
Yes.
He re-recorded the statements. And the money has been transferred to the accounts of the petitioner's personal firm.
Yes.
Not to the NECOF account. We issue notice.
No. That is one aspect of the case. But other aspect of the case, Lordship, kindly see, NECOF has sent money to me because that was my due. That Lordship may let me point out those things. Kindly see page 25. This is NECOF India has paid to Moromi Traders. Moromi Traders is my firm. So they have sent money which is due to me to my Moromi Traders. It is the signature of the general manager.
Maybe some different transaction.
No, how that can be? Because
how that question can be only examined when we get the records of the case. Yes, I have seen.
No, my lord,
I have seen. The accused received the complaint fraudulently transferred amount to 3 different account numbers instead of transferring the same to NACOP's official account number by causing harm to the complainant in age of so and so. So it is there. We'll issue notice at this stage. We'll call for the scan copies
It
of
is
the case record.
sent to me by NACOF. That is NACOF's pad has been used by that Samanta, who is the accused number 2.
We'll
Now,
call for the
he-
records.
Yes.
We'll examine.
That may examine, but till then some relief, my lord, because apparently case is a civil case, my lord.
We'll look into it. Heard Mr. M. U. Ahmed, Mahmood, learned counsel for the petitioner. And Mr. M.P. Goswami, learned additional public prosecutor for the respondent number 2, as informant, post of the petition, the instant criminal petition under section 528. B and SS is deferred for setting aside and quashing of the criminal proceedings of DR case number 33/2019, corresponding to Koromur Police Station case number 09/2019, and Sarsit number 73/2020, submitted in connection with Koromur Police Station case number 09/2019, full stop. The case, Goramur Police Station case number 09/2019 was registered for offences under section 406, 407, 417, 420 IPC. Oh, PRC case number 38/2021 within bracket GR case number. And after completion of investigation, the Sarsit was submitted, finding a privacy case well established under section 406 and section 417 of the IPC against the petitioner. Against the petitioner. Full stop. Mr. Mahmood, learned counsel for the petitioner, has submitted that the allegation of transfer of an amount of rupees 7,86,904 to the petitioner's personal account and to the accounts of 2 of his associates are contrary to the materials on record, full stop, to account instead of the account of National Federation of Farmers Procurement, Processing and Retailing Cooperatives of India Limited, within bracket NACOF India Limited, is contrary to the materials on record, as the petitioner had received amounts also from NACOF India Limited. Full stop. It was the petitioner who was to receive the amounts from the cooperative society. Full stop. The matter would require consideration, issue notice returnable on so and so date.
21st January 21.
As Mr. Goswami, respond number 2, the petitioner shall take steps for service of notice upon the respond number 1 by speed post within 3 working days from today. Matter would require consideration, issue notice, the TCR of PRC, scan copies of the PCR of PRC case number 38
3821.
stroke 2021. We call for post of
From the SDGM Majuli.
from the court of SDGM Majuli.
Majuli. Obliged.
Supplementary list, item 30.
Lordship,
Hmm.
Lordship, we are pursuant to the lodging of an affair. Trial commenced as session case number 38/19. Petitioners were, since then, 2019, petitioners were duly participating in the trial process. Now, page 10 is the impugned order, Lordship. On 30/10, on the two occasion petitioner defaulted because of some unavoidable circumstance. He defaulted in appearing and
Or what
space was
offense the case, session case is going on?
It is still for evidence, Lordship. Few evidence yet to be ammo and medical officer yet to be examined. In fact, I have newly engaged in the trial procedure also, so I know the
How
position.
many accused persons
How many accused persons?
in the trial?
One is 1, 2, 3, total 3, Lordship.
3.
3. All 3 are family members. And
Two Vaishya Kameshwar.
Kameshwar and Nipen Kumar. All
Kameshwar
3.
Kumar, Nipen Kumar.
And Nipen Kumar was defaulted in appearing on 30/10/2025 as well
Yes,
as
Mr.
28. Appear, Lordship. 70.
20. Okay. According to petitioner, default on 2 occasions. Default on 2 occasions, according to the petitioner, we don't know.
Yes, Lord. And 17/1 is the next date fixed, Lordship. Will appear in the 17/1, Lordship.
Till then, this Captain
Yes,
Evans,
Lordship.
heard Miss E. Shom, learned counsel for the petitioner. And Mr. MP Goswami, learned additional public prosecutor for the respondent number 1, State of Assam, post of having regard to the relief sought for, the criminal petition, present criminal petition referred under section 528 Bharatya Nagorik Surakha Hamita is taken up for disposal at the motion stage itself. Stop. Para. The petitioner has averred that on 20, in relation to an incident occurred on 28/8/2025, a first information report was lodged before. What is that? You have not annexed the main copy. Why? FIR.
FIR have next, Lordship. Page
Where?
9.
Where is the main copy? Oh. No, 11. Was lodged on was lodged on 2/9/2015, which was registered as what is the police station? Kayan, Kayan, police station, case number 41/2015.
Yes.
For the offenses under sections
294, 325, 307.
Of the Indian Penal Code, full stop. After investigation, the IO submitted a charge sheet under section 173(2) CIPC. Soliciting 3 accused persons, including the petitioner. Post of. The case was subsequently registered as Sessions case number 38 of 2019. Post of. When the trial court koribo, the case is presently pending before the court of learned
Additional dispensation judge, Rongia.
district and session judge within bracket FTS Kamrup Rongia. Post of. The submission of the charge sheet, when process was issued for appearance of the charge sheeted accused persons, including the petitioner, all of them appeared to stand in the trial. Post of. Para. It has been averred that the petitioner was regularly appearing in the trial until 30/10/2025. Full stop. The petitioner defaulted on 30/10/2025 due to reasons beyond control. The petitioner stated that he could not appear on 30/10/2025 as well as on the subsequent date, 28/11/2025 due to a number of reasons. Post of. The petitioner has averred that during that period, his father had fallen critically ill because of old age ailments, and the petitioner's father had to be admitted in a hospital. So as the petitioner was busy attending his father's statement, there was default on his part to appear before the trial court on 30/10/2025 and 28/11/2025. So, para. In the trial of Sessions case number 38/2019, 3 accused persons are standing in the trial, and the petitioner is one of them. Full stop. On 30/10/2025, the trial court, due to non-appearance of the petitioner without step, issued non-bailable warrant of arrest against the petitioner. Post of. Subsequently, on 28/11/2025 also, the trial court ordered for issuance of NBWA against the petitioner. Post of. As 3 persons, charge-sheeted persons, are facing the trial Sessions case number so and so, the appearance of the petitioner is a German factor, German GRMANE, to facilitate an expeditious conclusion of the trial. Post of. In view of the same, this court is of the considered view that the non-bailable warrant of arrest, issued against the petition by order dated 30/10/2025 and 28/11/2025, shall remain suspended till 17/1/2026 in order to facilitate a petitioner to submit himself to appear before the trial court on 17/1/2026 and to post of it is ordered accordingly. Post of it is further observed that if after appearance on 17/1/2026 the petitioner submits an application for recalling the NBWA before the trial court and for his release on bail, either on previous bail or press bail, the trial court shall consider such application on its own merits and in accordance with law.
I'm deeply offended.
Disorder dispose of the repeat.
Deeply offended.
Time being matter, item 8.
Quashing of FIR, my lord.
Rule FIR crossing CRD 09/120B. Okay. Where is the FIR?
Yes. Page 1/8 point. Make it long FIR?
1/8.
Yes, 1/8.
Reference. Inquiry report Jitendra Kumar Nath, you work 50. Yes.
Basically, FIR is against one video, my lord. Additional SP, my lord, he filed the FIR basically against video. Nothing was mentioned about me here, my
You are
I am Muhammad Jamaluddin.
Jamaluddin. Yes.
Nothing is there in the FIR, my lord, about me. If there is a scheme, my lord, the scheme was actually video. He was entrusted with the scheme and video has distributed to different NGOs, etc., my lord. So far, my name is.
Let us see the forwarding then.
Yes, in the forwarding, my name is there.
Let us see.
Yes. You also will find page 2.
Page?
Page 22.
Huh.
Page 22, paragraph 2, my lord. During investigation of the case, it has come into light that a full BRR check number so-and-so against an amount of 49,000 each has been copied from the original check which had been issued by the bank to the present petitioner, who is the secretary of a Life Career Society, Bangalmari. The original leaf of the check number so-and-so has been seized from the possession of the Jamaluddin connected with the case. During investigation, there is found sufficient evidence against the accused Jamaluddin for commission of the criminal conspiracy by preparing a fake check from his original BRR check with the help of other accused persons and other misappropriated the amount.
What is this? What is meant by this?
This is meaning by
Original
the
check, fake check. What is it?
fake check. Now, just
Now, what is the story here?
it will be clear here if you also kindly see.
How he this IO
Yeah.
says that force bearer check number so and so, number so and so.
Paragraph 3, you also kindly see.
Copied from original check. I am not understood it.
Regarding page 23, paragraph 3. During investigation of the case, your lordship, it has come to light that Sri Jogesh Chandra Bushya, the then branch manager of the Central Bank of India, Dolibari branch, I do not have any transaction with this branch, my lord. Should have to verify the authenticity of any check before the payment. He should have clarified that the bearer check number so-and-so issued against the private person. How could the BDO sign in the bearer check putting his seal and signature to pay the amount from government fund? But he did not do so. To prove the authenticity of the bearer check, rather the branch manager, Sri Jogesh Chandra Bushya, with the criminal conspiracy accompanied with some other accused persons with malafide intention, paid the amount from government fund, knowing the bearer checks are to be forged. Accordingly, he has been arrested in connection with the case on which he was also arrested, my lord. They are arrested, total, my lord, 4 persons arrested. Yes, Jogesh Chandra Bushya, Nur Jahan, Jamaluddin, and Shah Jahan. Now kindly come to my story, my lord, page, paragraph 8, my lord. How it happened. Page 12, paragraph 8. The lordship word.
But the fact of the matter is that you were recipient.
I am?
Recipient of the amount.
No. I have might have submitted, I am a secretary of an NGO. I have
Right.
submitted one check,
Hmm.
2 checks to the bank at Mukarma, not delivery. 4,000 rupees only, my lord. My check was overwritten. It was returned to me. And that check was seized by the police from my possession. So 409, my lord, section.
We'll
I-
issue a notice, then scan copies. It cannot be decided as on this
Oh.
date.
That is up to your lordship, my lord, but only for the stay, my lord, because your lordship, he is nothing.
You are on bail, you are on bail.
That, my lord.
We'll examine. But things are not that easy.
No, that I made party, informant also made party, my lord. Let him.
Third, Mr. H.S. Sodri, and it's also stated by Mr. A.T. Sarkar, Learned Counsel for the petitioner, and Mr. P. Sharma, Learned Additional Public Prosecutor for the respondent number 1, State of Assam, post of Para. Why by name?
Name because, my lord, because he has filed the FIR, my lord. Maybe he has say something else.
But in the capacity of,
He is the informant, my lord.
but in the capacity of DSP,
That is
It
there,
could
my
be
lord.
CID.
It is, but I made him for some reason, my lord.
okay. The instant criminal petition under section 528 BNSS is preferred for setting aside of
For question of the
criminal
FIR.
proceedings pertaining to CID police station case number 28/2018 registered under section 120B/409 IPC and the FIR lodged in that connection. First para, the petitioner was arrested, though Mr. Chaudhary Learned Senior Counsel, but the petitioner submitted that though there was no whisper in the FIR against the petitioner, but subsequently, the petitioner was arrested
What is
on
how we learn?
28/8/2025 on the allegation that he was a part of the conspiracy in issuance of two forged bearer checks amounting to rupees 49,000 each. Mr. Chaudhary has further submitted that the transaction with regard to the petition was limited only to rupees 4,000.
4,000.
4,000.
2 checks, my lord.
Uh-huh.
4,000.
2 checks of rupees 4,000
Paragraph 8.
each in his capacity
Yes.
as secretary of an
NGO.
NGO, VIZ, Messrs Life Career Society. Post of issue notice returnable on so and so day.
3001.
As Mr. Sharma. 1. Steps respond number 2 by registered speed post within 3 working days from today. To stop for consideration of the case projected by the petitioner, the perusal of the
Scan copy.
scan copies or a perusal of the concern. Any TCR number?
No,
FIR. TR case number 15223/2018, corresponding to CID police station case number so and so. Would be necessary to sublet scan copies of so and so be called for.
For admission, item number 16.
Probably be seen again. No problem. We have hardly any time. Before the break, hardly any time.
My lord, at 2 o'clock, I have got another matter fixed, my lord. Your lordship will accompany me for some time, man.
2 o'clock, I have another matter fixed.
Let it be
The
taken, then-
earlier one is serial number 15.
My lord, thereafter, your lordship may take up.
Okay, if time permits.
For half an hour, your lordship will accommodate me. Oblige.
Item number 17.
Yes.
Bail appeal, Lordship. Punishment for 10 years under section
Mr.
20B.
B. Haldar.
B. Haldar.
Heard Mr. B. Haldar, legal aid counsel
Legal aid counsel.
for the appellant. And Mr. B. Sharma, additional public prosecutor for the respondent number 1, State of Assam. Whether this information is necessary in a appeal, I don't think.
He is a IO, Lordship.
Not required.
Yes.
It is a appeal. Everything is over. This criminal bill under section 415 ENSS is directed against a judgment and order dated 3/10/2024 passed by the Court of Special Judge Karimganj in special within bracket NDPS bracket close case number 90/2022 by the judgment and order dated 3/10/2024, the accused appellant has been convicted for the offense under section 20 within bracket small b within bracket small Roman 2 within bracket capital C of the Narcotic Drugs and Psychotropic Substances Act 1985, and he has been sentenced to undergo rigorous imprisonment for 10 years and to pay a fine of rupees 1 lakh, with default stipulation. First up, I have gone through the grounds urged in the memo of appeal. The appeal is admitted for hearing. Issue notice returnable in 4 weeks, as Mr. Sharma has appeared. Correspondent number 1, State of Assam. The issuance of notice with the respondent number 2 informant is not necessary. First up, let records of special case number so and so be called for. Yes.
There is an IA for suspect.
NDPS, let the records come.
Item 18 for orders.
Don't expect for.
Matter, my lord, referred to mediation.
Failed.
Failed, my lord, matter was, my lord, 79,000 odd. Here we offered 5 lakh, my lord, there, my lord, we offered 11 lakh. My lord, once they agreed, they said 30 lakhs. Now, my lord, they are asking for 1.8 crore.
Let us hear.
Oh, that's here, my lord, there is no other.
Let us hear. 2009. Today itself.
After vacation, any date, my lord.
Why? 2009.
I'm ready, my lord. I cannot.
You
There is no
ready?
difficulty on my part.
Ready? Okay. Second half. Mediation failed.
Yes,
No
my-
scope.
Yes, my lord.
Item 19.
This leave petition, my lord, appeal against acquittal, my lord.
Huh?
Appeal against acquittal, my lord.
Where is the appeal? The order?
My lord, it starts from 15, my lord. Page 15.
Page?
Page 15, the
Page.
judgment, my lord.
Judgment. CR case. Judicial magistrate first class. Change.
This is the leave application.
CR case.
My lord.
Complaint.
Complaint.
Acquittal.
Acquittal.
Offenses.
Of the 498A, 417, my lord.
Is there any restriction for filing an appeal under the proviso to 372?
No, my lord, it will come under 374A, 4.
No,
378, 4.
earlier I am saying earlier 372 proviso, CRPC.
My lord.
Now I have to see the corresponding one.
372, my lord, pertains to GRK. Earlier, 372, my lord, GR case.
You are the wife.
I'm the wife. We,
You are the, who lost the informant?
the appellant lost, applicant lost.
Appellant. Lost the FIR.
FIR.
And
Complaint.
complaint. And you are the victim. You are the victim wife.
No. I lodged the complaint against the husband.
Right.
Husband got acquitted.
Right. Jyoti Sharma. So you were the wife.
I'm the wife.
And you were the complainant.
Complainant.
Right. You lost the
Complaint.
Complaint against your husband and his family members. Right?
Fine.
So you were also the victim. You were beaten up.
Fine.
Cruelty was meted to you.
Fine.
So, in view of interpretation
Fine.
of victim and complainant by the Supreme Court in the Mallikarjun, Kodagili, and recently in Celestium, if the complainant is the victim also,
Fine.
right? In that case, there is no bar to prefer an appeal for such a complainant victim under the earlier proviso to 372 and presently, what is that?
Presently, 372.
I don't remember this.
Becomes to
BNSS. BNSS. These appeals are near 415, right?
Yes.
413 proviso. Or not?
But there is a 419 minus.
378 4 I know. This is under what?
4194. 378 378 4 earlier.
Earlier 378 4. Now presently?
4194.
4194. Now, have you read Celestium?
No.
Read Celestium along with Mallikarjun Kodagili and come back. If and another one judgment of Justice Padiwala that this is not a proviso, it is the provision itself, substantive provision for appeal. So if the suppose had your mother,
victim,
no, had your mother been the informant, then the complainant would not have been, sorry, had your mother been the complainant, then she would not have been the victim.
Right.
But since you instituted a complaint,
Victim, my lord, mother would also be a victim. My lord. Yeah.
there is also an interpretation in somewhere,
Yes.
right? So whether this would be, there would be an appeal or to the court where it would lie,
Essence.
or it will be under that, or you say 378(4) CRPC or 51419
419.
subsection.
I'll look into it and get back.
So then it will have another forum. That is session judge. Find out the interpretation given by in Celestium.
I'll
If the complainant is the victim, as per the definition clause in PNSS or CRPC, then it would be open for such a complainant victim to exercise the right of appeal under the proviso to
372.
378(4) or 4194 PNSS. If that is so, then why should we burden ourselves with this appeal?
I will
Right.
go through, my lord. I will.
Think it over.
Yes.
Tomorrow, go through it. Celestium also.
Celestial.
Celestium by Justice Nagaratna. I'll list the case tomorrow. Yes, Mr. Pang, anything?
My lord, item 24 was there taken in first week of January, man.
Well, pass.
Yes.
If somebody else.
Yes.
He's appearing for the other side, in item
Oh.
number 18. He says that we'll let it not come after vacation.
Sometime. Okay. Because it is 2009 matter, that is why I am.
Let it be on, my lord, after reopening on 8th, my lord, if not inconvenient to my lord. 8th of January.
Okay. Take time. Okay, Mr. K. Agarwal, Senior Counsel for the petitioner, and Mr. P. Kotogi, Learning Counsel for the respondent, are jointly submitted that the case be posted on 8th of January 2026 for hearing.
Yeah, hearing. Let it be heard, ma'am.
For
2009
hearing.
matter.
For hearing. List the case accordingly. On so and so. Number 20.
May I please your lordship? Lordship, here the complainant in the NIA case, lordship, he defaulted to appear on 3 occasions, lordship. Before the court took cognizance of the matter, as such the matter was dismissed for default. And against the order of dismiss for default, this criminal appeal has been filed. Now in this criminal appeal, a leave has also been filed, a leave petition. And in the leave petition, there is a delay of 271 days, lordship.
271 days.
271 days. However,
Waiting
lordship,
notice.
however, there is an issue, lordship, in this matter. After the matter was dismissed for default, he filed a criminal revision petition before the session judge, lordship, by mistake, lordship. So he had spent 239 days in the lordship will for a moment take up the delay application, lordship. IA for delay 1344. 1344. After dismissal of default of the NIA case, lordship, he filed a case before the additional session judge. And in the time period spent by him during that proceeding is 239 days, lordship. This he has stated at para 3 and 4 of the IA. And
Mr.
lordship,
Sharma,
yes, lordship.
this is a, what is the case under section?
419, lordship. Of
No, enact.
enact.
Have you gone through the Celestium judgment?
Celestium judgment. I have gone through An earlier judgment, Lordship, of 2016, wherein Lordship, both section 413 and 419 has to be read conjointly.
No, law has been laid down. No, law has been laid down.
Regarding leave petition.
No leave required.
Then Lordship, I shall.
And appeal would lie under section
413.
413. You see, because complainant in NIA case
A victim.
is also a victim, and therefore an appeal would lie.
That is the law, Lordship.
Celestium Financial.
Then Lordship, I shall
Look into
not
that.
press the, I shall not press the leave petition.
Look into that, because what the session judge has said.
Session judge order in the leave petition on, IA Lordship will find for delay, page 10. Page 10. Page 10, operative page 11. Small order, Lordship. Complainant is absent without any steps. Peruse
No,
the
no.
case record and
When you prefer the revision,
revision date I can give, Lordship. It was filed on 7/25. Within 1 month.
Mr. Sharma, there is another judgment. When the case is dismissed for this. 1 minute. Where is the order of the dismissal of the complaint?
Page 11.
There is another judgment authored by former CGI Sanjeev Kumar Khanna. When after on dismissal of for default under 256 CRPC.
256.
You read that.
Lordship, for a moment, page 17. Lordship.
Sanjeev Kumar Khanna also, you have the judgment. Law
No,
have been laid down.
The settled position of law has been narrated. It has been stated by the learned additional session judge, Lordship.
Where is that?
Para 10, page 17 of the IA.
Page 17.
Page 17 of the IA, para 10. Page para 10. It starts with so, Lordship. So, last 5 lines. So, if it is
Read,
taken,
read the entire para.
starts at page 17, para 10. Now, it starts with now revisiting the impugned order.
Further, did not specifically mention the provision under which the case was dismissed for default, but it appears that provision of another attract in the case as the case was not dismissed after examination of complaint and other witnesses making inquiry. However, given the nature of the case in hand, the provision under section 270 also does not affect in the case as section applies to foreign cases and the case falls under the category of summons post. So the case in hand falls under the category of summons as stated as such inferred by 256 deals with appeal. I don't know this is correct or not.
Then liberty is also granted. The next paragraph, Lordship.
No, the law which I have indicated,
Yes,
sir.
yes. That is the law of the.
Please look into that. Sometimes dismissal of the complaint does not result in acquittal. That is what, and 256. There are two situations. One appeal will lie, other may not lie. Please look into that judgment. We'll keep it on day after tomorrow. Otherwise, I will make a vote. And secondly, in view of Celestial, appeal lies.
Yes.
Appeal lies.
That I will not.
Right. If it is appeal lies, then you have to prepare an appeal before the court where normally appeal lies. Meaning thereby,
Yes, sir.
go through it Celestial Financial, then the other judgment authored by Justice Sanjeev Kumar Khanna, former CGI. Come back on Thursday. Place the case on Thursday.
May it please your lordship.
Yes.
Lordship, steps have been taken, but the ID
Issue
card
notice
has not been
of
received.
another administrative. What is the status?
ID card is not.
Yes,
received.
Mr.
MP Das.
MP Das, Learning Council, but a petition applicant is present. Peruse the office note dated 1/12/2025. First off, await for the service report in respect of the sole respondent. Release the case up to 2 weeks.
May I please? Your
Yes, Mr. Som.
Lordship, one half conviction have been served, your lordship, by the applicant. One half conviction have been served by the.
One half.
Yes, your lordship. Punishment was 7 years, lordship. And punishment was 7 years. And till date, your lordship, 3 years, 6 months, 4 days have.
Yes, Mr. Musabi, what is the law? Huh?
Speak for hearing.
Where is the judgment? Impugn judgment?
Impugn judgment.
The appeal memo. Page 9. Abdul Hakim Karbi.
It starts from page 9.
54. Use persons. How many appellants?
3 lordships.
Doyananda Biren sentenced to undergo 7 years. Judgment is of 39. Since judgment, they are in custody.
Yes, your lordship.
Yes, what is the law? Yes, please. After a long time, I have said. So it takes me at least 1 week to get myself refreshed. You are the person who is dealing with criminal cases all the while.
Your lordship, in another similar matter, your lordship has passed a
Fixed term.
judgment.
Huh.
Referring lordship Bhagavan in this your lordship 1999 4 SCC 421, that judgment was at paragraph 5, your lordship referred, lordship.
So from
Lordship, from 39.
September 2022.
Yes, your lordship.
So it is 3 years and 3 months.
3 months.
Plus
And
during investigation,
3
3
months,
months.
2 days,
So 3 years, 6 months.
6 months.
And sentence is 7
7
years. Yes. Hard. Mr. Ayasho. So we are having 2009 revision in the single bench. Applicants. Appellants. The informant has appeared. Yes, what do you say? But 3.5 years. Mr. MP Goswami Lanet, additional public prosecutor for the opposite party, that's respondent number 1, State of Assam, and Mr. Your name, please. P. Mozumdar Lanet, counsel for the opposite party, that's respondent number 2. Full stop. It is under 389 or 430.
It is 430, Lordship.
The instant application under section 430. Bharatiya Nagarik Surakha Act 2023 is preferred seeking suspension of execution of the sentence passed against the appellants and for their release on bail. Post of para. The applicants as appellants has preferred the accompanying criminal appeal, criminal appeal number 274/2022 against a judgment and order dated 13/9/2022 passed by the Court of Sessions, Karbi Anglong at Diffu Trial Court in Sessions case number 28/2017 within bracket new, again bracket of it, Sessions case number 133/2015 old. Full stop. By the judgment and order dated 13/9/2022, the learned trial court had convicted the appellants for the offense under section 304 capital B Indian Penal Code read with section 34 IPC, and all of them have been sentenced to undergo rigorous imprisonment for 7 years. No default clause. Para. What is your case on merit?
Lordship, on merit, Lordship, only PW1, your Lordship. There is allegation from the side of only PW1 who is informant. There are altogether
And
11,
who is informant? Mother or father?
Lordship,
You don't know?
Lordship, I know. Lordship.
Huh?
Father, Lordship, Vijendra Das.
Ah.
Only he implicated the.
Mr. Shroom, counsel appearing for the appellants has submitted that the informant was the father of the deceased, and his evidence is hearsay in nature. Full stop. There were no eyewitnesses
No.
to the alleged incident? Burning
No,
or
Lordship.
what? Or other than the family members of the in-laws of the deceased. Full stop. How many witnesses?
11 total.
Any eyewitness? No.
No, Lordship, no idea.
None of the 11 prosecution witnesses was had seen the incident. Post of Para. Mr. Shom has further submitted that during the period of investigation, the applicant's appellants were in custody. No, the appellant number 1, right, was in custody for a period of 3 months and 2 days. Whereas the other 2 appellants were not arrested. Post of. Subsequent, since the delivery of the impugned judgment and order dated 13/9/2022, all the appellants are in incarceration till date. Full stop. He has further submitted that the appellant has number 1 has already spent more than 3 years, 6 months, which is more than half the period of the substantive sentence. Most of the other 2 appellants have spent 3 years, 3 months, more than 3 years, 3 months,
Lordship.
in incarceration. Full stop. Para. Here paragraph 522. The Supreme Court of India in Bhagavan Rana Shinde Gosai versus the State of Gujarat, 1999 4 SSC 421, has observed that when a convicted person is sentenced to a fixed period of sentence, and when he files an appeal under any statutory right, suspension of sentence can be considered by the appellate court liberally when there are exceptional, unless there are exceptional circumstances. Full stop. Having regard to the projections made on behalf of the applicant's appellants and the period of sentence already undergone, this court is of the considered view that the applicant's appellants have made out a prima facie case for suspension of the sentence pending disposal of the appeal, which has already been admitted for hearing. Post of para. It is therefore ordered that pending disposal of the appeal, execution of the sentence passed against the applicant's appellants shall remain suspended, and the applicant's appellants are allowed to be released on bail, subject to furnishing a bail bond of rupees 20,000.
Lordship.
Each with 1 surety of the like amount to the satisfaction of the trial court. To stop, the interlocutory application stands disposed of in the aforesaid.
Oblige, Lordship.
Mr.
Yes, Miss Anne Yepto.
No, Lordship. I'm not in a list, Lordship. The victim mentioned for the,
Direct counsel for the
can a matter be passed over for a time being, Lordship?
petitioner and Mr. MP Swami Learned, additional public prosecutor for the respondent number 1, State of Assam. Full stop. Where is the office note dated 4/2/2025? Full stop. The petitioner shall take first steps for service of notice. Upon the response number 2. To the office of the public prosecutor, Guwahati High Court. Full stop. On furnishing a copy of the notice, the public office of the public prosecutor shall cause service of notice upon the response number 2 to the jurisdictional police station, and thereafter submit a report. Thereafter obtain a report as regards service of notice. Full stop. The such steps on behalf of the petitioner shall be taken within a period of 3 days from today, release the case after 4 weeks. Yes, spying was making a mention. Huh? Yes, what is your prayer?
Lordship is unwell. The candidate fixed on
Okay.
first week of January. Lord.
Not Thursday.
No, first week of January.
On the not first week, after 19. On the prayer of Miss
A Pine.
A. Pine, learned counsel has learned counsel for the petition has made this is appeal. Okay. Appellant has made a prayer for adjournment, which is not objected to by Mr. MP Gussamil and additional public prosecutor for the respondent state. Full stop. As release the case on 21st of January. Yes. Yes, Mr. Boromir. Why it has come?
My lord, the step
Crossing.
was taken, my lord, and our information is that, my lord, information notice received by the informant.
What the case that has been received. Neither ED card nor answer notice. Received back by the section.
Daughter, my lord, married. Now husband and wife before your lordship.
Service is not there, huh? Service is not complete.
Maybe, my lord, our information, my lord, private level, my lord, he got, my lord, notice.
Has been filed with a praying for quashing of POXO case.
My lord, married, my lord, they are.
Who married?
My lord, it is both petitioner, my lord.
Huh?
At least, my lord,
Let us see the FIR first, then I can understand. Habibul Tehera. Okay, okay. Yes. He is saying married. What was the age at that point of time?
my lord, 18 years plus, my lord. They are.
How can be? From where you are saying? Affidavit
Yes, my lord. One.
or birth certificate?
Yes, my lord. No, my lord. This page 20, my lord.
Page 20.
And they have, my lord, male child also, my lord. Relevant paragraph, my lord, page 22, paragraph 6, my lord.
Page 20. What is this?
Page 20.
Agreement. Notary agreement. Huh? That does not prove the age.
Yes, my lord. Paragraph, page, my lord, paragraph 8, my lord, there is a male child also.
And who is the informant?
And my lord, I have just.
Who is respondent number 2?
Respondent, my lord, the father informant, my lord.
So you know the address?
Yes, my lord. It is.
You know the address?
Yes, my lord.
Get the notice served.
My lord. Prop.
Crossing.
Papers.
Dosti is not permitted. Huh?
In POXO case, my lord, throw, my lord, we are, my lord, their office, my lord, we are taking step, my lord. And
That in criminal petition also. Also, you are noting also. Notification also. And Mr. M. Borhuyan, Learned Counsel for the petitioners. And Mr. MP Goswami, Learned Additional Public Prosecutor for the respondent number 1, State of Assam. Full stop. Here is the office note dated. Case has been charge-sheeted.
Charge sheet.
15/12/2025, wherein it is reported that neither ID card nor answer notice has been received back after service upon the respondent number 2. Full stop. As per notification, a petition shall take first steps for service of notice upon the respondent number 2 as per notification number 17 dated 15/3/2024. Full stop. Petition shall, for the purpose of causing such service, the petition shall furnish a copy of the notice, serve a notice, copy of the notice to the office of the public prosecutor who, full stop, the public prosecutor shall obtain a report as regards service from the jurisdictional police station. Full stop, is the case after 4 weeks.
Oblige.
Please, Your Lordship.
Yes. As the praying for crossing Sarsi.
Lordship, we have taken the steps, Your Lordship.
Charges were being issued notice 2 and 3. Mister? 2 and 3. Okay. Service is complete. Now, scan copy of TCR is awaited. Heard Mr.
M. Siddiqui, Your Lordship.
M. Siddiqui, Learned Counsel for the petitioner, and Mr. MP Goswami, Learned Additional Public Prosecutor for the respondent number 1, State of Assam. So, Miss B.S. Oja, Learned Counsel, has submitted that she has entered appearance on behalf of the respondent number 2 and 3. Full stop. As all the respondents are represented, all the respondents are therefore represented. Full stop. As per office, as per office note, dated 15/12/2025, the scanned copies of the TCR have not been received. Full stop. Issue a reminder for the scanned copies of the TCR. Release the case on 28 January. You said in your written argument,
Indeed, Your Lordship.
right,
Indeed, Your Lordship.
that the vice president,
Indeed.
sorry, for election to the vice president, the authorized officer himself
Conducted the toss.
tossed the coin,
Indeed, Your Lordship.
right?
Indeed, Your Lordship.
Now, come to page 68.
Your Lordship, this is with regards to the representation which the petitioner has
It
submitted.
is your representation.
It is my representation.
Right.
Here, your Lordship.
Then the fourth paragraph starts with the BDO took a personal rupees 1 coin from his pocket. Then next, invited an unauthorized and unknown individual to conduct the coin toss.
Indeed, your Lordship.
Allowed that person to toss the coin on the ground and declare the result as tails.
Indeed, your Lordship.
Declared Muhibur Rahman as president based on this informal lottery.
Indeed, your Lordship.
Then repeated the same process
Indeed,
for the post of vice president, again favoring a candidate from his group.
Your Lordship. 2 points with regards to that, your Lordship. One is with regards to the entire representation which we have made. We have brought a concept with regards to the coin, your Lordship. This same process is with regards to the coin which was used for both the elections, your Lordship. And even if after the coin also had submitted, this is a part which is an erroneous representation or erroneous mention with regards to the vice president, which is not a subject matter of the entire petition, your Lordship. So that part, that should have been reflected in the resolution, your Lordship. This is a representation, but the resolution does not talk about it for the entire procedure. The resolution is silent, your Lordship. That is our entire case, your Lordship. That if in the same transaction, twice, 2 different procedures are adopted, your Lordship, and which should have been reflected in the resolution. And this is with regards to the coin, that the same coin was used twice. Which
Yes, anything?
Yes, resolution. Yeah. Working instead of following the legally mandated process, rule 50, acquired the rule 55 is bounded. Not mentioned.
Rule
Apart from this-
45, I don't know.
apart
I
from
know
this-
only rule 45 or 55. I know only for 45.
Rule 45.
45.
That is
Invited an unauthorized and unknown individual.
Ah.
Where is unauthorized and unknown individual? And in presence of the BDO who has authorized this person conduct it well. Now resolution in respect of resolution, my lord, page 9, my lord, 55.
Page 55.
55, my lord. Page 5, my lord, authority part is page 7, second paragraph,
55.
7.
57.
55, third.
Ah.
Second paragraph, 57. After the ending of the votes, counting observed that both the parties is equal vote. The designated officers on meeting now toss conduct for the election. The meeting, all the members present gave consent and support the toss and which someone wins the toss. Now their consent, resolution passed by the members and they put their signature. The same is reproduced as a my lord, by a furthermore, page 58, my lord. Second paragraph, after the 10 votes. After the ending of the votes, counting is observed that both the parties has issued equal votes. The designated officer has been informed with the meeting that toss will the election of the vice president candidate. The meeting, all the members gave consent to the toss. Husnara Begum wins the toss.
Yes, Mr. Counsel, where have you stated that for the post-election, at the time of election of the vice president, the authorized officer himself tossed the coin in the writ petition?
indeed, your Lordship. In the writ
No,
petition, we have not mentioned, as it is not a part of our dispute, your Lordship. We are only concerned with the president election, but in the course of argument, when it went to the vice
Don't
president,
develop such argument as
But
a counsel
the
when
fact
it is not a pleaded case.
our case is only
Please-
vice president,
please
your Lordship.
Don't go beyond the pleading,
Indeed.
right?
Indeed, your Lordship.
And if you, in the pleading, you may have raised 10 grounds, right? Then you may have the choice of confining it to 2 grounds.
Indeed.
But it is not that you have contended 10 grounds and you'll expand it to 15 grounds.
Indeed.
Don't
Yeah,
do it and waste the time of the court.
Ours is only president election.
Right,
Indeed,
but don't develop and try to give, develop a written synopsis and argument, which is not in the, because I saw your written argument, right?
May I
This
please
is
sub-
my
May I please submit one line on that, Your Lordship? It developed because the question was asked that why did we support the vice president election? To that question it developed because we
No,
were
no,
not going in that
yes,
line.
your written, I saw
In-
your
in-
written
Indeed, Your Lordship.
argument and I marked it.
Indeed, Your Lordship.
And I tried to find out where is your pleaded case, right? In a writ petition, you can plead 10 grounds,
Indeed, Your
right? At the time of argument, you may argue on 5 grounds,
Indeed, Your Lordship.
but it is not the vice versa, that
Indeed, Your Lordship.
you plead 10 grounds
Indeed, Your
and you argue on 15 grounds,
Lordship. Indeed, Your Lordship.
right?
Indeed, Your Lordship.
So when it is not your pleaded case, right?
Indeed, Your Lordship.
Don't develop such argument because it has to be based on
Indeed, Your Lordship.
pleading, right? You said that authorized officer himself
Indeed, Your Lordship.
in bold,
Indeed, Your Lordship.
and I tried to look into that. And by looking into that, I wasted few minutes, right? And I have to remember it myself to put you across.
Indeed, Your Lordship.
Don't
Indeed,
do
agree.
that
Indeed, Your
in
Lordship.
future, right?
Your Lordship, with regards to this consent part, page number 60 to
I have
75. sir.
understood.
The consent part is not the
That is
consent.
your first ground.
It is not the consent, Your Lordship.
That is first ground.
It is mentioned in the resolution also, Your Lord.
That is first ground. And where is the standing council available? No, neither election commission. Okay. Okay, now get a legislative. If possible, I'll try to deliver it today, or otherwise I'll keep it reserved,
Indeed.
right? So you referred to B.V. Gopinath
BP Gopinath, Your Lord.
and one Afreen Begum Afroza Parveen, right?
Your Lordship, we have another more if you can submit at this.
We have heard you enough.
Much obliged.
And there is no issue to be decided regarding election tribunal.
No, no.
That points are not argued by any of the council.
Indeed.
So we leave it for decision in an appropriate case.
Indeed. Your Lord. Deeply obliged.
If Mr. Dutta, I'll try to pass the order today. If not possible, I'll keep it reserved before vacation. Somebody else.
Deeply.
My lord, regarding Afroza's case, it is regarding second time speaking.
Second, one toss, two calls. One toss, two toss.
Yes, two toes. In respect to my case, it is not a.
Deeply.
It was 16. 16.
Did I keep it parted or what? Why it has come?
It was heard for about an hour.
Last occasion means
No, the
the previous.
Long back. Whether I kept it parted. Because otherwise I'm not holding the roster.
In fact, my lord, both the sides want the matter to be parted before your lordship.
It was in April.
My lord.
We are in December. I have forgotten
My lord,
many things I have forgotten. Yes.
now, my lord, this is, my lord, primarily is regarding, my lord, the acquisition of land for the Oil India Limited for its oil exploration. And the order which has been challenged is passed by the Deputy Commissioner, holding that the earlier proceeding, land acquisition proceeding, there were two land acquisition cases. Those have lapsed, and the compensator has to pay it under the new act. And while the amount has also been calculated, and these two orders are under challenge before your lordship. Okay. Now, my lord, before I take your lordship to the impugn orders, I'd like to give a little background about the, my lord, procedure that is followed by the Oil India Limited, my lord, for acquisition of, my lord, acquiring land for its, my lord, purpose, because, my lord, the government is also, my lord, duty bound to provide the land. But what the oil does is that, my lord, after it identifies a particular plot of land, my lord, the owner is approached. And it is always the endeavor of the oil to have the, my lord, bipartite settlement. And on the basis of that, my lord, the amount is to be fixed. And, my lord, both the parties normally agree, my lord. The proceeding is not required to be, my lord, initiated under the Land Acquisition Act. Here, my lord, there was a, my lord, procedure followed. And eventually, my lord, the landowner did not agree to that. Now, my lord, the requirement is like this, my lord. Because as for the, my lord, bipartite procedure, under the Assam Land and Revenue Regulation, my lord, Rule 190, then, my lord, it is proceeded, a bipartite procedure. If fails, my lord, all requests DC to grant the right of entry. Because initially a right of entry is to be, my lord, started Land Acquisition Act and this Land and Revenue Regulation. Your lordship comes to, my lord, is 54, 54A.
54A means
of the, my lord,
repetition.
of the petition, man.
Okay.
This is a communication from the, my lord, Oil India Limited to the Deputy Commissioner. May I read it, my lord? Right to entry under Rule 190 of the Assam Land and Revenue Regulation 1886 in respect of the land involved in our proposed drilling locations. The locations are given within at village Pukan Pukri, grant number such and such. With reference to the above, we hereby apply afresh for granting us the right of entry under Rule 190 of the Regulation 1886 in respect of the land involved in our drilling locations.
These
In
are
this-
my abbreviation of drilling locations.
My lord.
This is HNE, HNF.
These are the, my lord, the locations of that specific places,
In-
my lord.
Technical terms.
Yes. In this context, we are enclosing here with the schedule of the land likely to be involved in the above mentioned locations along with the copies of the land map showing each location separately. Further, we'd like to inform you that as per our prevailing practice, any existing public or tea garden road required to be used by oil for its operational needs is developed and maintained by oil during the period of operation. If any land required for widening the existing road or for the above purpose, additional land is acquired by us. Therefore, as regards the approach road leading to our drilling LOC DET falling within the Hukanpokriti estate, we only propose the additional land garden road which will construct, develop and maintain during our operational period. However, the plinth as well as the small portion of the approach road in respect of our drilling LOC as shown in the map belonging to the private patterers, occupiers will be taken over by us under private negotiation. In case the private negotiation fails, we will approach you separately for grant of right of entry under Rule 190 of the Assam Land and Revenue Regulation 1886. In view of the urgency of the oil exploration program, as per MOU with the Ministry of Petroleum and Natural Gas, we request you to grant the right to entry under Rule 190. Now, Your Lordship may kindly peruse the provision, the Rule 190. Yes, sir. Good hearing. Good. It should be in page 126, my lord.
I have found.
I'm so sorry, my lord. In this book, those pages are not there, my lord. I took it from the library. I'm sorry. Please get on. May I read, my lord?
Yes.
Conditions of a mining lease. Where the surface of any land covered by a mining lease is in the occupation of any person other than the lessee shall have the liberty and power to enter upon such lands in the exercise of rights granted by the lease, provided that without the consent of the occupier and in the absence of such consent without the written authority of the Deputy Commissioner, he shall not enter into any building or structure or into any enclosed yard or garden. No surface operation shall be carried on in or upon the site of any dwelling house or in such a manner as to injure the buildings. The similar provisions there. Then 3, the Deputy Commissioner shall not grant authority under clause 1 or 2 unless he is satisfied that the right conferred by the lease cannot be exercised except by grant of such authority. On receipt of an application for authority to enter upon any land or to injure any property under clause 1 and 2, the Deputy Commissioner shall immediately publish at his office and on the land concerned a notice that such authority has been applied for. No land which is in the occupation of any person other than the lessee shall be used for surface operations if any other lands not so occupied is suitable and available for surface operations. The lessee shall not, without the express sanction of the Deputy Commissioner, cut down or injure any timber or trees, but may, without such sanction, clear away any brushwood or undergrowth which interferes with the exercise of the right of granted by the lease. The Deputy Commissioner may assess or cause to be assessed any damage or injury which may be done by the lessee to the property of the occupier, and such land and other persons may order amounts so assessed to be paid. In assessing any damage or injury under this clause, the assessor may leave out of account the value of buildings, so and so. My lord, so under this provision, my lord, the permission was, my lord, asked for right of entry. Now, my lord, your lordship will find thereafter, my lord, BC grants the right of entry. Your lordship finds at page 56. Okay. This is an order passed by the Deputy Commissioner and Collector, Tinsukia. Whereas Oil India Limited Duliajan has applied for sanction of the authority by their letter number such and such to interpret, then my lord, your lordship may skip second paragraph. Now therefore, in exercise of the power conferred by Rule 190 of the Assam Land and Revenue Regulations 1886 and in terms of the said drilling locations, I so and so, IAS Deputy Commissioner and Collector, Tinsukia District, do hereby serve this notice upon all concerned that the Oil India Limited Duliajan has been granted authority to enter upon and to carry out surface operation under the land mentioned in the schedule below, as per the rights granted to them by the drilling locations HNE, HNF, initially for a period of 180 days with effect from the date of issue of this order. Under Rule 190 Roman 2 of the ALRR 1886, the Oil India Limited Duliajan has also been given written authority to remove any dwelling, houses, buildings, other structures standing on the land, or any cultivations on the land mentioned in the schedule. Damage or injury cases to such houses, buildings, other property shall be assessed, and the amount so assessed be paid to the person concerned. Then, my lord, the surface compensation was assessed. Your lordship finds at page 68. So, my lord, we have paid the surface compensation, entered into the land with this permission, and my lord carried out our operations. Page 68, your lordship will find, my lord. Payments have been made, as have been assessed. There is no dispute to that, my lord.
Why some repetition numbers are referred to?
My lord, the some writ petitions, those were filed by Messrs. Nandalan and Sons of my lord, challenging the virus of the rules, but those are not, my lord, relevant for the purpose
No,
of.
in the receipt, something is mentioned about WBC, 3 WBC numbers.
In the receipt, yes, my lord.
In the receipt. 1680, 1722, 1681 of 2020,
Yes, my lord.
2002.
My lord, there were proceedings earlier. My lord, I have prepared a list of dates with a brief note. May I place it before your lordship? Copy it or other side of diya.
Some earlier litigation.
Yes, my lord.
From 2002.
I have jotted down, my lord, the important points and the list of dates.
Okay.
Or in order to save time, my lord, may I read this, my lord? Preliminary submissions, the petitioner Oil India Limited is engaged in exploration, production and transportation of crude oil and natural gas. For this purpose, oil acquires land in various parts of India, primarily via bipartite settlement. In case of failure, acquisition is sought under the Land Acquisition Act 1894, 2013, Petroleum and Mineral Pipelines Act 1962, and Rule 89 and 190 of the regulation. The instant writ petition challenges the order issued under memo number such and such dated 13/4/2023 passed by the Deputy Commissioner Tinsukia, whereby it was held that no government approval existed prior to the issuance of the letter dated 16/7/2011 in LA case number 192 and 193 of 2011 under Section 11 of the Land Acquisition Act 1894, and consequently directing that further proceedings in the said LA cases shall be conducted under the provisions of the Right to Fair Compensation Act 2013. And the second one is, my lord, the letter dated 27/5/2023, whereby a revised award estimate has been submitted under the new LA Act 2013, enhancing the compensation from 11 crores to 22 crores. Now, your lordship has already seen the order, my lord, that permission, right of entry. Then, my lord, serial number 327/11/2020, the Oil India Limited took physical possession of the said land. Then oil paid surface compensation. Then landowners filed 4 writ petitions. And this court, by the judgment dated 5/4/2011, directed the Deputy Commissioner Tinsukia to initiate a process under the Land Acquisition Act 1894. Notification under Section 4 of the LA Act was issued on 20th of May 2011. Then notification under 6 was issued on 17/9/2011. Then there is a meeting, a minus of the meeting dated 34/2011, whereby the Deputy Commissioner Tinsukia has approved rupees 10 crores and odd per bigha as rate for the land in Hukanpukri Tea Estate. Award order dated 3/5/2011 issued by Deputy Commissioner fixing the rate of rupees 10,07,872 per bigha for land in Hukanpukri Tea Estate as a special case. Then on 11/5/2011, the DC Tinsukia issued a letter intimating the registrar of this honorable court that the land acquisition proposals have already been prepared and forwarded to the government, while later dated 7/5/2011. Oil filed an objection. Oil's objection dated 18/5/2011 to the said fixation of rupees 10,07,000 and odd per bigha as a special case for land in Hukanpukri Tea Estate with a prayer to review the land value. Then government approval dated 13/10/2011 approving the land acquisition estimate amount of rupees 39 lakhs and odd for allocation number 193 and 5 crore 90 lakhs and odd for allocation number 192. Deputy Commissioner Tinsukia on 17/11/2011 directed the oil to deposit the award amount of rupees 39 lakhs in allocation number 193 and 5 crores and 90 lakhs in allocation number 192. An Oil India Limited raised objection to the fixation of land value in both the LA cases and requested DC Tinsukia to review the valuation of land in LA case number 192 193, while later so and so. My lord, had this objection not been made, perhaps, my lord, at that time the matter would have been settled, my lord. We were, my lord, my lord.
Perhaps you were not there.
I was not there. The oils thought that this is on the higher side. That's why, my lord, they approached.
At every point, earlier also on 18/5, it was objected to 10,07,872. I think oil objected.
Yes.
So if there is objection, then there is no agreement. There was no agreement.
There was no agreement.
So at that point of time, it was negotiation.
Yes, my lord.
Once Section 4 notification has been issued,
then, my lord, that
everything has to be by the Act.
Yes, my lord. Then it has to be under the Act.
Section
No, what I
6.
mean to say is, my lord, had the objection been not raised, my lord, the things would have been settled at that price. It has
Yes.
escalated, my lord,
Again, finality.
so many times.
Then they would have, if they, say, if they are aggrieved, they would have gone for reference.
My lord.
Now it is you who is litigating. Yes.
The oil raised objection to the fixation of the land value in both the LA cases and requested Deputy Commissioner to review the valuation of land in LA case number such and such. DC Tinsukia communicated oil while later dated 16/7/2011, which was received by oil on 5/11/2012. This is important, my lord. The letter was issued on 16/7/2011, but it was served on the oil on 5/11/2012 about the fixation of the land valuation amount at rupees 10 lakhs and odd. On receipt of the letter dated 16/7/2011 on 5/11/2012, oil requested DC Tinsukia to rectify the date of issue of the letter, while later dated 9/11/2012.
So serial number 12 and 13
My lord.
of the table, when government approved the land acquisition estimate, it was at what value? 10 lakh per bigha?
Yes, my lord.
10 lakh per bigha?
My lord. Yes, my lord.
Okay. Yes.
Then, my lord, the oil.
Just a minute. In the erstwhile LA Act,
My lord.
Which provision? You are in what position? You are requiring authority.
I'm the requiring authority, my lord. After that, my lord, section 4 and section 6 notifications.
Because
are
you have to
issued.
make a request
Yes, my lord.
that I need this land.
Yes, my lord.
Which provision is applicable then?
They are under the regular act, my lord, because the Assam Land and Regulation, my lord, that that has passed, my lord.
And the provision is later put in.
Because section 4 notification will be issued after we submit the requisition.
That'll be quite correct, sir. As a requiring authority, I'm just asking.
My lord.
You are a requiring authority. You have asked the acquiring authority to acquire land for you. Right. And he makes an estimate. Maybe falling short of an award, makes an estimate. So what is the role for you to object to the estimate? Under the statute,
My lord, the
at the then existing LA.
my lord, it really does not provide there no LA.
Because the earlier act,
LA.
you cannot
Application.
demand any reference.
Corona Home.
Meaning that, in other words, you cannot object to the estimate prepared, perhaps, if you are the requiring authority.
Because, my lord, that is really a question in the reference court only, my lord, perhaps. Your lordship is
Because,
right.
yes,
Your lordship is right.
the requiring authorities look at section 50.
In determining the amount of compensation, the collector shall be guided by the provisions contained in section 23 and 24.
No, not the new act, old act.
Yes, my lord.
50.
50. I was reading 15, because there is a guide, section 15, my lord, it's there.
See anything, because you read 44B also.
Yes.
You being a government company or a company, you are entitled to ask for acquisition.
My lord, section 50 says,
Ah,
where the provisions of this act are put in force for the purpose of acquiring land at the cost of any fund controlled or managed by the local authority or of a company. The charges of any incidental to such acquisition shall be defrayed from or by the fund of
such fund or company.
such fund or company.
2.
In any proceeding held before a collector or court, in such cases, the local authority or company concerned may appear and adduce evidence for the purpose of determining the amount of compensation. Provided that no such local authority company shall be entitled to demand a reference under section 18.
And section 44B. Just because you do not fall under section 44B, so you can invoke section 50.
land not to be acquired under this part except for certain purpose for private companies other than government company.
So since you do not fall
In
in private company, you are government company, so you can invoke that, yes, DC, please acquire this land for me. And I will bear the fund.
expensive. But in my lord, here
Your
also-
rule is limited to subsection 2.
Yes,
So you objected,
yes.
right? Then next point is
Objection was overruled.
overruled. But thereafter, let's see again the course of events. By the time LA gone,
By the time LA had gone, my lord, the question basically is here, my lord, whether there was an award passed under the, my lord, old act or not. That is the question. My lord, if the award was passed, my lord.
what are the requisites?
My lord, after my lord, section 4, section 6 notification, my lord, they make the assessment and my lord pass an award. That award has to be passed, my lord, that was the issue. Because according to the deputy commissioner, my lord, no award was passed. Records are with them, but the communications reflect that, my lord, the award was passed, government had approved it.
Let us see the provision. What are the requisites?
After my lord, the enquiry is conducted by the collector, my lord. Thereafter, under section 12, my lord, the collector has to pass the award.
Such award shall be filed. Which is the award according to you?
No, my lord, award, we don't have a copy of the award, my lord. But we, my lord, placed before the court saying that these are the communications which reflect that there is an award. I'll be referring to those communications. Now, my lord, this honorable court has issued certain directions that your lordship may like to, my lord, know at page 4.
Page?
Page 4, my lord.
Page 4, okay.
Oil
Yes.
India Limited file WPC 5372 of 2013.
Serial number?
Page number 4 of this, my lord.
See, given in bold.
18, my lord.
18. Yes.
In fact, my lord, 18 is the annexer number, my lord.
Okay.
I am referring to the annexers for your lordship's convenience. Oil file WPC so and the honorable court by common judgment dated 8/2/2017 passed in WPC 587 of 2017 and 5372 of 2013 had directed the DC to revisit the provisions of the later dated 16/7/2011 and arrive at a proper and due compensation payable to the petitioners by following due procedure of law. Here, my lord, the question was again on the amount of compensation. That annexure 18 is at page 110, given the page number.
Is 112. Whose petition was this one? The respondent's petition.
These are our petition.
100, page 10.
That is, my lord, the petition filed by the private respondent, my lord.
It was in 2017.
Yes, my lord.
And if we go by the content,
Lordship, there were cross-read petitions. One by them to revisit 16/7/2011 and one by us, 587 of 17,
Yes.
for asking for adequate compensation.
Right, now if we
Subsequent.
go by the contents in page 111.
Now, we filed the petition in 2013
Yes,
and the respondent filed the petition in
17,
2017.
17 subsequently.
Right, if the language of the order, say page 111, as the last line,
As the land acquisition case has already been initiated, this court is of the view that the petitioners are not being paid the compensation as because the said proceeding has not been completed.
if that is the finding already recorded,
My lord. Then, there is a direction to revisit.
revisit, but revisit is in the meantime, significant development has taken place. And perhaps there is incorporation of section 24,
Yes.
perhaps.
Yes, my lord. And on
And
that,
that's will change the scenario perhaps.
exactly, my lord. I'll be relying on the decisions of the Honorable Supreme Court on, my lord, section 24. My.
Okay.
But that
But
will be the,
this finding has been recorded.
this has been recorded, but then, my lord, if your lordship reach further, my lord,
Please.
in the aforesaid circumstances as agreed by the parties, this
As agreed.
my lord, this is an agreed order.
Agreed, meaning thereby it was not completed.
It was not complete.
We cannot travel beyond that.
Yes.
You agreed. You are the council.
Oh, no, my lord.
Yes, Boni Essence Pharma. Okay. Okay.
In the aforesaid circumstances, as agreed by the parties, this representation is disposed of with a direction that the Deputy Commissioner cum Land Revenue Officer Tinsukia District would immediately pursue with the land acquisition case of 192 and 193 of 2011 and bring the same to its logical end. Meaning thereby the Deputy Commissioner will arrive at a definite determination as to what compensation is required to be paid to the petitioner. So, my lord, only the compensation amount was in issue. Because, my lord, it has already been observed that the proceeding has not been completed.
So there is no award.
Correct.
There was no award, my lord, till that time.
Till that time.
My lord.
Because once award is passed, LA proceeding stands terminated.
Yes.
There will be reference thereafter.
Yes, my lord.
So that finding is conclusive so far as LA case is concerned. Did
That
not
it was
end
not
till
completed.
that point of time.
But this order is, my lord, of
Let us read further.
my lord.
Let us read further.
The next paragraph. In terms of the above, the writ petition stands closed with regard to WPC 5723 of 2013, which had been filed by OIL, which is the organization for whom the land has been acquired. It is seen that the writ petition is against an impugned letter dated 16/7/2011 of the Deputy Commissioner Tinsukia. From the said letter, it is seen that the Deputy Commissioner had fixed an amount of rupees 5 crores 90 lakhs and odd against LA case number 192 and 39 lakhs against order LA case number 193 purportedly as per the order of this court in WPC 1680 of 2002 and these 4 writ petitions. It can be seen that the aforesaid writ petition pertains to taking over the land of the petitioners by OIL under Rule 199 and 190 of the rules under the Assam Land and Revenue Regulation. But the said by the said writ petition, and challenge was made by the landowners to the aforesaid taking over of the land. By the order dated 5/4/2011, the said writ petitioners were closed without interfering to the taking over of the land, but directing the DC to take a decision after hearing both the parties and strictly in accordance with the applicable law. The aforesaid direction by this court in the judgment and order dated 5/4/2011 cannot be construed to be a direction by this court to the Deputy Commissioner that the Deputy Commissioner would make an assessment of the aforesaid amount without following any due procedure of law. In view of the above, the Deputy Commissioner is directed to revisit the provisions of the letter dated 16/7/2011 and arrive at a proper and due compensation payable to the petitioners by following the due procedure of law.
This is what? This part is what? Regarding requisition amount. Because section 4 notification
Yes.
initiated the land acquisition proceeding.
Yes.
Prior to that, there was no process of land acquisition. And this, I don't know, this paragraph 112, it says purportedly as per the order of this court in WBC number so and so.
My lord.
It can be seen that the aforesaid petitions pertain to taking over the land of the petitioner by oil under section rule 189 and 90. That is for surface compensation.
No, no, my lord,
Because this order, if I read, if I have correctly understood, 5 crore 90,000, 90 lakh and 39 lakh. These are what? This order says this is
that's prior.
requisition amount or taking over surface compensation.
Must be, my lord. Must be, my lord.
So if this is surface compensation, then there is nothing. So far as land acquisition.
Land acquisition is concerned.
So that I have understood correctly. Please correct me if I am wrong. As per the text and tenor of this part of this order, that these are all surface compensation. Let us see 16/7/2011.
16/7/2011 order. Your lordship finds at, my lord, page 108.
108.
108. Annexure 16.
I like to know the sum of rupees so and so against the electors now against
It was in fact, my lord.
what is 5/4/2011 judgment?
My lord, that was with regard to the, my lord, the bipartite agreement that was, my lord, according to the oil.
Para 9, he is very specific. 6th line. Very specific, Deputy Commissioner.
Page 108, my lord.
108.
My lord.
Line number 6.
That's a high court.
Where will
Lordship, that's the high court, the first high court order.
I think
The-
I don't have this.
Yes, Your Lordship, you will find this order at page 74. Lordship, what happened was they took possession in 2000. When they took possession in 2000, we challenged it. The right of entry we challenged.
Oh, I have got it.
Yeah.
Okay.
Right of entry we
That
challenged.
part, I think last part. Is it not?
Yes.
Last part.
Yes.
Para 9. Right. This 5 crore is surface compensation.
Lordship, there's a confusion because what happens, Lordship, may kindly take a look at page 79. That's the High Court order.
Let us read paragraph 9 first.
Okay, Lordship, at
Page
108, 108.
81.
Yes, Your Lord.
Please read, any of you.
Paragraph 9, my lord. In course of the arguments, the learned counsel for the petitioner has urged that the acquisition of the land, if done, the compensation awardable would relate to the period on and from which the same is initiated by a notification under section 4
What
of
is
the Act.
notification dated? Section 4 notification?
Is
Date?
subsequently
Date, please,
2511.
Huh?
2511. 20th May 2011.
Now read further.
And does it claim with regard to the, for the period prior to such proceeding would remain unattended?
Right. Prior to.
Yes, my lord.
So be prior to 25/2011. Now let us read.
In
Would
the
remain
above,
unattended.
in the above view of the matter, we consider it appropriate to permit the petitioner company to lay its claim vis-a-vis the land for the period and on from which this possession had been taken over by the respondent oil till the initiation of the land acquisition proceeding under the Act. If such a claim is made by the petitioner company, the Deputy Commissioner Tinsukia would take a decision thereon, and after hearing both the parties strictly in accordance with law applicable thereon. This issue would be independent of the one for the compensation under Land Acquisition Act and would be undertaken by the Deputy Commissioner parallelly and completed within the period of 3 months from the.
Now, where is
Name of
the
the
letter
petition.
dated 16/7/2011? Once again.
108.
108.
108.
Lordship, in between, there is a DC order, which may clarify
We'll come
what
to
your
that.
lordship
Let
is.
us
Yes, sure.
not divert. 108.
108, your lordship will find that, my lord, it was the amount fixed in the, my
Let
lord.
us read. Let us read.
My lord.
Hmm.
Regarding payment of compensation amount fixed and ordered in LA case number 192 and 193 of 2000. With reference to the subject cited above, I'd like to inform you that a sum of rupees 5 crore 90 lakhs and odd only against LA case number 192 and 39 lakhs and odd against LA case number 193 was fixed by the Deputy Commissioner Tinsukia as per Honorable High Court's order in WPC Such at para 9 of the
He is
judgment.
very specific.
My lord, yes.
This is surface compensation.
No, this
Prior
is
to 25 2011.
no, that was with regard to the, my lord, that bipartite, my lord, agreement.
Whatever, this figure, 5 crore something and 39 lakh was not regarding any LA compensation.
That is a LA compensation, my lord. The LA compensation.
Because he has specifically referred to para 9.
Yes.
Because para 8 is regarding you initiate acquisition proceeding.
Yes.
And para 9 is prior to
Yes,
acquisition proceeding,
yes, prior
which
to the-
is surface compensation under Rule 189 and 190 of the rules framed under ALRR 1886.
My lord, there, my lord, the land acquisition compensation is
No,
also
this,
applicable under.
no, LA case is, this LA case has been referred to for the parcel of land, specific parcel of land.
Well,
In
maybe-
one, some bighas, in one, 50 plus bighas. No, we are reading it together
My lord.
so that no can misconstrue the order. Let us read further.
My lord, let
Let us read further.
My lord.
Whereby
As per High Court's order, at para 9 of the judgment and order dated 5/4/2011, whereby a meeting was convened on 30th April 2011 at DC's office chamber, along with representative of Oil Duliajan Garden Authority of Hukanpukri Tea Estate and District Administration, wherein the overall gross value of the land, my lord, not surface, of Hukanpukri Tea Estate under acquisition was fixed at rupees 10 lakhs, my lord, per bigha. So this is, my lord, not surface compensation.
let us read. Let us read.
Bigha only for the instant case. The rate was approved as a special case and will not be applicable to other oil-related cases or any other acquisition whatsoever. The value of the land was fixed as per valuation report received from the circle officer Tinsukia at such and such rate. And damage under clause 23(1) of the LA Act for rent for use of the land.
He is 12 years. When did you take over?
My lord,
Which
taking-
way?
November,
Uh,
November to.
My lord, the
November 2000.
Yes.
But this 12 years, why this 12 years? Because there is no question of land acquisition compensation at that point of time. Why he has calculated for 12 years? There is no question of 12 years.
My lord, from the date of entry.
That is why there was no acquisition in 2000 up to 2000 until section 4 notification.
True, my lord, but at the same time, because they
That is not acquisition. That is right to entry or use.
right to use, my lord, and thereafter, because of the bipartite agreement which the, my lord, respondent.
Bipartite failed.
Well, that is what is reflected here, my lord.
Bipartite failed. That is why you said, please give us right to entry. Then DC passed the order for right to entry.
Yes, ma'am.
So without the consent, DC can pass if it comes within your lease areas. Right? And you got the right to entry order.
Yes.
So these are just a minute. this is completely alien to the land acquisition process, perhaps.
Now, my lord, may I read the, my lord, last but one point
Huh.
again, my lord. The value of the land was fixed as per valuation report received from the circle officer Tinsukia at rupees 4 lakh so and so per bigha, and compensation amount under section 23C of the LA Act and damage under clause 23(1) of the LA Act for use of the land for about 12 years at rupees such and such, together with totaling such and such amount. Therefore, you are requested to deposit the aforesaid amount of compensation of the land under acquisition to the office of the undersigned immediately. Now, my lord,
Perhaps this is in reference to paragraph 9 of the judgment.
9, true, my lord. Then, my lord, this was under challenge, and there is another order, my lord, I'll draw your attention to that.
Which page, Ms. Goswami, you wanted to?
No, Lordship, just for clarification, Lordship sees 5411 was the order which says initiate paragraph 9. Yes, Your Lordship. Now, Lordship, page 91. 91 is immediately after that because there were two parts of the order.
Mr. Choudhury, I'm not stalling.
Sorry, yeah, even I don't mean to interrupt. I'm just clarifying just so that there is no ambiguity. Page 91. So after that, the DC, this is the
91.
DC order.
Land has been initiated for acquiring land for so and so currently under possession. Approved land value. That's what.
Paragraph 4 is.
Tripartite agreement.
Yes, Your Lordship. This is what the learned senior is referring to. And paragraph 4 is important. Zonal valuation is still underway. And approval is mandatory. Therefore, interim. Lordship, the second last paragraph. Whereas the tripartite was held on 3-4. Lordship has the second last paragraph of page 91.
Yes.
Whereas as per tripartite meeting dated 30th/4/2011 in DC office, both parties agreed to abide by the order of the DC for enhancement of land value in Hukan as an interim measure pending zonal valuation. And thereafter, Your Lordship may see the 10 lakh valuation comes. This is an interim valuation prior to section 4.
Then taking this valuation forward,
Yes.
he proceeded to
16th,
calculate the
absolutely
that right to use
Yes.
surface compensation for previous 12 year perhaps. Subject to your correction. This is my query to the
My
to
lord,
both of you.
Perhaps, my lord, subsequent orders will clarify that. Now, your lordship may.
This challenge, if that is so, this challenge will be an independent challenge. Because paragraph 9 says that this issue would be independent of the one for the compensation under Land Acquisition Act.
True, my lord.
So if this challenge you lay, if it is surface compensation, then this is independent challenge to the challenge made under for the acquisition process. This is, if I am correct, then this is surface compensation for 189 and 190 of the
12 years.
settlement rules,
For 12
right
years.
to entry. You take
Yes,
it over,
my
I have just read.
My lord.
And second part is acquisition process.
Actually, my lord, ultimately the issue, your lordship, which is false for your lordship consideration is, my lord, whether, my lord, under the new act, this is accepted or exception or not. That will be the issue.
So you have to say that award should be in what form?
Award has to be.
This part goes, it looks like prima facie, tentatively that 5/4/2011 is for surface compensation.
My lord, this order will perhaps. throw some
Otherwise,
light.
you would not have mentioned paragraph 9 and for 12 years.
And
that issue exactly figures from your taking over of the land.
In 2000.
2000. That fits.
That fits.
Right.
But then your lordship will kindly peruse the subsequent order of this court, my lord.
Yes.
At page 111.
Yes.
Where, my lord, this order, 108 order was challenged by the respondent, man.
That is why page 112, third para,
No, no,
is
they have challenged.
in tune with is in due third para.
Yes.
Is 5,90,000 and 39 lakh, right? This is in tune with surface compensation, third para.
10 lakh. Yes.
It is in tune with
Yes.
surface compensation. He said revisit whatever for surface compensation, but so far as LA case 192 and 193, please take it forward and bring it to the logical
My
conclusion.
lord, for the time being, let us accept that, my lord.
Subject to correction,
Well,
but this order is date of the order 8/2/2017.
yes, my lord. We do-
Because that
Date is important, my lord. That
date
year
is important. And
Now the-
have you challenged this?
16.7, Lordship, oil has challenged. We did not challenge.
No, 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 no.
No, nobody is
This-
challenged. This is
110
good.
finding,
My lord, the,
8/2/2017, nobody is challenged.
because the
No.
single judge has said, take it forward.
Yes.
yes. We approved the court in, my lord, 2013.
Huh? The judgment has been delivered, and where is your order? The order in the writ petition preferred by you?
This is the order, my lord.
Common order,
Common order.
8/2/17.
Two order, your
Okay, with regard to
110, page 110, your lordship will get the
your petition number is
5372 of 2013.
that is regarding surface compensation again.
Page 112, your lordship may kindly, my lord.
I have seen. This is for you, third paragraph.
My lord.
Writ petition stands closed with regard to WBC number 5372 2013.
Which
You
have been-
challenged 16/7/2011.
My lord,
That is fixation of, if I am not wrong.
my lord, compensation, my lord, surface compensation.
So far as acquisition process is concerned, there was no challenge. If that is not challenge, the order of passed in their writ petition, that please take it forward
Yes.
in 2017. It bears significance because by that time, RFCT
New act-
2013 Act has
new act
come
has
in.
come.
So by operation of law, section 24 will pitch in.
That is there where my
This is
lord,
my tentative view subject to correction.
my lord.
And thereafter, it is to be taken to logical conclusion.
If your lordship, my lord, kindly comes to page 97, my lord. In 2011 itself, my lord, this order was passed by the government. What was placed before the court and what really happened in the, my lord, with the departmental
Land
authorities,
acquisition
my lord,
estimate
your
of
lordship will
taking
find, this is a communication from the government in the revenue department to the deputy commissioner. Approved land acquisition estimate in respect of LA case number 193 for acquisition of land for deeding location. I am directed to forward here with an approved copy of the land acquisition estimate amounting to such and such only for acquisition of land for the above project under LA case number 193. And so far as the other, my lord, the proceeding LA case is concerned, that your lordship finds at page 101. Here, my lord, in the other case also, my lord, directed to forward here and approve, I'm reading 101, my lord. The government and the revenue department to the deputy commissioner, I am directed to forward here with an approved copy of the land acquisition estimate amounting to 5 crores and 90 lakhs and odd, only for acquisition of land for the above project under LA case number 192 of 2011 for necessary action from your end. And then, my lord, at 105, your lordship will find, my lord. 105 and 106, the direction was given to us to pay the amount. 105 is the type copy, 106 is the, my lord, original copy. If your lordship, my lord, kindly reach page 105. By the, my lord, Deputy Commissioner to the government, submission of acquisition proposal of oil exploration. With reference to the subject cited above, I have the honor to forward here with the following documents relating to the land acquisition case number 192 and 192 of the Hukanpukuri Tea Estate of Ramagora Moja Tinsukia Revenue Circle in connection with the acquisition of land for oil exploration in favor of your kind provision and necessary draft publication under Rule 4.1 of the LA Act 1894. Then, my lord, the commissioner's approval, your lordship will find that your lordship has already.
Before that, again, just the interruption, sorry. Page 97.
My lord. Government to the Deputy Commissioner. Approved land acquisition estimate in respect of
That is
allocation.
correct. Now, come to next page.
Value of landlord's interest.
Why Deputy Commissioner was interested for annual rent? For calculation of annual, page 98.
This is, my lord, 98 is estimate of the probable cost of acquisition of land under 1894.
Right. Extreme right column. Because we are mixing up two things together. Right.
Annual rent.
One is compensation, surface compensation, something like that. And another is land acquisition. Right. Now come to page 98. Why Deputy Commissioner was interested for annual rent at rupees 77,000. He proceeded thereafter. Collection charges at 10%. What are the use of these terms?
For the purpose of land acquisition, my lord, this is.
These are not terms.
Not relevant point.
Not relevant. Why he went on
But then,
going, calculating, then arrived at a figure of 39 lakh
my lord,
on
this
the
was.
basis of annual rent.
Yes,
Because this 10% has significance in the sense that why he had added.
No, but then your.
The collection at charges at 10%. Then you read that his own earlier one, 8.7.
No, if your lordship will also kindly read page 99, my lord.
I have seen.
My lord.
That is also seen. I don't know how he has arrived at this figure, but he has written some annual rent and etc. Which
Does not.
and has no connection with anything related to LA Act.
No, perhaps, my lord, he has calculated both, my lord. One is the
I don't know.
surplus
Deputy
compensation.
Commissioner can explain. I don't know the calculation formula, right? For surface
That
compensation.
is, my lord, in respect of the, my lord, that paragraph 9.
Again, 102 also, he started for annual rent, then collection charges at 10% minus. Then he said
No, that has to be, my lord.
574. Why rate per bigha? Then he calculated how he calculated. But what are the things to be added under section 23?
No, my lord, if your lordship will kindly read paragraph 9 of the earlier order again, my lord, because that has to be in terms of that High Court's order. Paragraph 9, your lordship has already read at page 81.
23. Let me find out 23.
So there are two parts of this order, my lord.
Two parts.
In the, my lord, in the order of this honorable court, my lord, there are two parts. One is regarding the surface compensation, the other is regarding the land acquisition. Land acquisition is dealt with in paragraph 8 and paragraph 9, my lord, that's surface compensation as your lordship had.
If you read section 23, this is absolutely not land acquisition estimate.
No, my lord, what I'm on, my lord, what I'm trying to impress your lordship is that, my lord, the High Court order is in two parts. One is regarding, my lord, compensation of the land.
Yes.
If your lordship, my lord, reads the judgment again, page 79 regarding that, my lord, compensation.
Paragraph 9 was at which page?
Paragraph 9, your lordship finds at page 81. But
It
then,
is
my lord,
important to read paragraph 8 also,
Yes,
page
yes.
80.
Fine.
I have read. I have read.
So this part,
Two parts in the judgment.
yes. There are two
And
parts.
if you read this page 2, 3, 4, as well as 98, 99, and 100.
Yes, my lord.
These are not calculation in terms of section 23 of the Act. There is nothing, no terms, because say section 23 matters to be considered in determining compensation.
Yes.
Right. In addition to the, it is market value. Okay, let us take journal value further. As above, the court shall in every case award an amount calculated at the rate of 12% per annum on such market value for the period commencing on and from the date of publication of the notification as section 4.
Yes.
Section 4 was only in May.
May.
Even if it is May, where is the interest?
My lord, if your lordship comes to page 99, my lord, 99 they say about, my lord, the if your lordship comes down below after the chart, market value of the land under section 23. Firstly, so and so amount has been given, then damage, nothing has been, total compensation has been, my lord, stated, no damage. Then, my lord, capitalized value has been added. Then cost of establishment added, additional cost of contingency that has been added. Interest part is on there.
And subsection, most important, subsection 2 of section 23. We are testing whether this is an award under LA Act or it is surface from.
Yes, ma'am.
Section 23, subsection 2.
In addition to the market value of the land as above provided, the court shall in every case award a sum 30% on such market value in consideration of the compulsory nature of acquisition.
Where is that?
That is only court, my lord.
No. Court, once it is an award in determining compensation.
In addition to the market value of the land as above provided, the court shall in every case award. So, my lord, that did not be calculated there.
First, you have to satisfy me that this is an award.
That is the issue, my lord. That is the issue whether there is an award or not.
Because the judgment is already there. There are two parts into it.
Yes, my
one
lord.
by you, one by the other one. In their petition, the court has ordered, please take the acquisition proceeding forward.
Yes.
In 2017. And in your petition, the court has ordered that please revisit
Yes.
this 8/4/2011. And you were agreed by that particular letter, impugn letter 8/4/2011.
Yes.
Which was for what? It was for if their petition is disposed of, saying that please take the proceeding, land acquisition proceeding forward.
Yes.
Then it cannot be read. That second part, that please revisit, because if that is read, then award is already there. Have you understood my
Yes,
dilemma?
Yes. My your lordship has put a very correct query, my lord. But then, my
Because
lord, your
the
lordship,
court interpreted 8/4/2011.
yes.
Right. And 8/4/2011 speaks of 12 years. Something related to 12 years, which cannot be
Land acquisition.
in a land acquisition award. So cases, these two parts have been jumbled up. And it has been going on.
My lord,
If I have understood correctly, I have just looked at the papers
my lord.
earlier in April now. So please, otherwise there is, because of the date is significant, 2017.
Yes. I will employ your lordship to read this order again, my lord, at page 106.
Okay, let us read. But thereafter we'll put it forward in the new year.
Yes, my lord.
We'll keep it part
Yes.
but not this next 3 days. Now I'll remember. Page?
Page 106.
Yes. Hmm.
This says, my lord, to the Oil India, that in inviting a reference to the subject, I am requested to kindly deposit the estimated amount of rupees 39 lakhs and odd only against LA case number 193 of 2011. And next page, your lordship will find, my lord. This is with regard to 192, LA case number 192. 5 crores and 90 lakhs and odd. This cannot be surface compensation. Looking at the rate.
Then come to 8/4/2011. Again, page. Page 8/4/2011.
Lordship, the first 5/4/2011, page 74. Paragraph 9 order you.
Page not 74. No, after the judgment. After the judgment. After the judgment that.
Lordship, the second challenge to 16.7 is at page 110.
16/7.
Yeah.
Where is that page?
That is at page 110. 8/2/2017. Order.
Which starts at page 111.
111.
11.
No. That. Paragraph 9, where is
Lordship,
it?
that is at page.
108.
Page-
108. Which was challenged?
Yes.
Yes, 108 was challenged.
And let us see the minutes of the meeting 34/2011.
34/2011.
Page 89.
Page 89.
34/2011, at that point of time, the elect was not initiated. This is important. This must be taken note of. There are two things into it.
Yes.
One, he fixed 10 lakh 7,872. Then by order page 91, he again on interim, Deputy Commissioner fixed, so it is collector, 10 lakh 7,872 per bigha, and any enhancement of rate, because he took it as 2005 sold it, right? Then he said general valuation would have retrospective effect, right? Now please come to 97. This is 39 lakh 26,000
Yes, Madam.
for 2 bigha something perhaps. 3 bigha 2 gatha 14 less.
As per allocation.
Then 101. 5 crore 90,000, 90 lakh 94,000 for acquisition of land.
Fine.
Now if you add those two figure, it would come around less than 6 crore, right? Now come to 108. It is very specific to paragraph 9. He took out the same formula, but arrived at a figure of 10 crore.
Yes.
7,000. This is a different figure. And this is for 12 years. What multiplicand, multiplier, what method he had adopted, this is a completely different figure. And this is meant for paragraph 9 of the judgment. And he took out 10 lakh as the general valuation, arrived at this figure. There is distinct figure, two distinct figures. This 10 crore is something else. Now you have to say, because by page 97 and 101, this is 39 lakh and 5 crore 90 lakh. It is around 6 crore 30 lakhs. This is specifically for award, acquisition. But this 108 is a different figure altogether. See the figures. I don't know what formula they have, the Mr. Nath
Somewhere it is found.
has for surface compensation, but he arrived at a completely different figure, 10 crore. And why 12 years should come? Page 108. Have you understood?
Yes, my lord.
So you challenge this one. But these two went unchallenged. Think it over.
I get your lordship's point.
And you took forward this 16/7/2011 letter by filing a writ petition. And they took forward the other two by filing another writ petition.
In 2017.
Right. And ended in 2017 by that order. The land signature said, please take forward the land acquisition cases. And so far as this one, please revisit. If that is so, then section
Whether there
24
was a, my lord, there was an award or not. Now,
Please, no.
then, my lord, there is a subsequent, my lord, proceeding that your lordship finds that judgment of this honorable court at page 140, it starts at 140. 140.
This is what? The case.
Paragraph 2, certain land of the respondent number 3, Nandalal and Sons Industries Private Limited, Chabua in WBC so and so to be referred to.
Which
as the land-
paragraph?
Paragraph 2, my lord.
Hmm.
That is the subject matter of the writ petition. Sometime in the year 2000 for their own operational purpose. The issue raised by the landowner before the state respondent authority is that no compensation as payable under the law had been paid to them by the petitioner Oil India Limited for the land. The process resulted in an earlier proceeding in WPC so and so that has been, my lord, quoted. Paragraph 9.
Paragraph?
No, my lord, in paragraph 2, my lord. The earlier order.
We are at page 130.
142 I am reading.
Oh,
my lord.
142.
It's the judgment.
What is paragraph this page? Oh, there are another repetition
Yes,
by
ma'am.
you. 7797. What is that?
My lord, challenging the order at page 116, my lord.
116. 116.
116, my lord.
Oh, that is. That further process will be carried out under the 2013 Act.
Yes.
Okay. Then what happened
That
at
was
page
pending.
132?
Initially, my lord, there was a stay. Then, my lord, your lordship may skip the other, my lord, portion because paragraph 9 has been quoted. Then your lordship may finally come to paragraph 5 at page 145.
There were many other repetitions. Or one repetition. Then another one. 7797, same.
We also
Okay.
filed 629 again for compensation.
You
because-
also filed?
Yes, because we were not getting
Okay, okay,
compensation.
629.
90 of
Okay.
17 for compensation.
What happened then?
Then, my lord, may I read paragraph 5, my lord,
Paragraph 5.
at page 145. In the meantime, my lord, in view of the earlier order, we have already deposited 1.5 crores. That is also there, my lord, earlier. Page 146, my lord, that has been recorded by this honorable court that we have deposited the amount. Now, by the order dated 16/7/2011 of the Deputy Commissioner, Tinsukia, the appropriate authority of Oil India Limited was informed that the Deputy Commissioner has fixed an amount of rupees 5 crores and all and 39 lakhs in respect of LA case number 193, 2012 and 192. The communication also provided that the said fixation by the Deputy Commissioner was as per the order of the High Court dated 5/4/2011 in WBC 1680/2002 and other repetitions which had already been.
Where is the figure of 5 crore 90 lakh in this letter dated 16/7/2011? Okay. Okay. It is clear then.
Yes, my lord. Then the.
Please, yes.
I read
Yes.
further.
Yes, please.
The communication also provided that the said fixation by the Deputy Commissioner was as per the order of the High Court dated 5/4/2011 in WPC 1680/2002 and other representations which had already been referred here and above. The Deputy Commissioner in the communication also provided that the valuation was made by taking the value of the land to be 10 lakhs and odd per biga. The aforesaid two repetitions, WPC 5372/2013 and WPC so had been given in consideration by the order dated 8/7/2002, by which a tentative conclusion was arrived at that no award could be located to have been made by the Deputy Commissioner under Section 11 of the Act. Accordingly, Deputy Commissioner was directed to revisit the order dated 16/7/2011 and arrive at an appropriate compensation that may be payable to the landowners. As regards the other parts of the judgment dated 5/4/2011 and other writ petition, it was provided that the said order dated 8/2/2017 that the Deputy Commissioner may take his own decision as regards the compensation for the period prior to notification under Section 4. In the aforesaid circumstances, the present writ petition is instituted assailing the order dated 21/5/2017. Then, my lord, paragraph 10 at page 147. Your lordship's query is perhaps answered in paragraph 3 of this. Paragraph 3 of this judgment, my lord, at page 143. 143. 3. Paragraph 3. The reading of the aforesaid extract of paragraph 9 of the judgment dated so and so and other representation makes it discernible that the division bench had distinguished the period of taking over the land by Oil India Limited into two parts. The first part being the stage prior to issuing the notification under Section 4, and the other part being the period subsequent to issuing of the notification under Section 4. In the premises, the division bench provided that the claim of the landowner for compensation for the period prior to notification under Section 4 being issued, the Deputy Commissioner Tinsukia would take a decision after hearing both the parties and strictly in accordance with the law applicable thereto. But the issue would be independent of one for compensation under the Act 1894. In other words, the division bench has made it explicitly clear that for the period prior to issuance of the notification under Section 4 of the Act of 1894, the Deputy Commissioner would take a decision on the amount of compensation that the landowner may be entitled to. And such decision shall be independent of the compensation that is required to be paid under the Act of 1894. Now, paragraph 11. Paragraph 11 is the, my lord, of the same judgment, my lord. A reading of the order dated 3/5/2011 of the Deputy Commissioner Tinsukia does not enable this court to arrive at a conclusion as to whether the said order fixing rate of rupees 10 lakhs and odd per bigha is an award under the Act of 1894. A perusal of the record does not make it discernible that there exists any award under Section 11 of the Act of 1894, which was made prior to 5 years of the date of the Act of 2013 coming into force. Although a confusion may remain whether there is any such award in existence, but at least no award is discernible which may have been made prior to 5 years of the date of the Act of 2013 coming into force, which came into force on 1/1/2014. As no award is available on record that may have been made prior to 5 years of the date of the Act of 2013 coming into force, we are in agreement with the submission of the learned senior counsel, Mr. So-and-so, that the provision of Section 24(2) of the Act would be inapplicable in the present case. Let us see what is 24(2). Land acquisition process under Act of 1894 shall be deemed to have lapsed in certain cases. Notwithstanding anything contained in this Act, in any case of land acquisition proceeding initiated under the Land Acquisition Act 1894, where no award under Section 11 of the said Land Acquisition Act has been made, then all provisions of this act relating to the determination of compensation shall apply. B, where an award under said section 11 has been made, then such proceedings shall continue under the provisions of the said Land Acquisition Act, and if the said act has not been repealed, as if the said act has not been repealed. Number two, notwithstanding anything contained in subsection 1, in case of land acquisition proceedings initiated under the Land Acquisition Act 1894, where an award under the said section 11 has been made 5 years or more prior to the commencement of this act, but the physical possession of the land has not been taken or the compensation has not been paid, the said proceeding shall be deemed to have lapsed, and the appropriate government, if it so chooses, shall initiate the proceeding of such land acquisition afresh in accordance with the provisions of this act. Provided that where an award has been made and compensation in respect of a majority of landholding has not been deposited in the account of the beneficiaries, then all beneficiaries specified in the notification for acquisition under section 4 of the said Land Acquisition Act shall be entitled to compensation in accordance with the provisions of this act.
Now, what is the deputy commissioner said? I have read.
My lord, subsection 2 is very important, my lord. That is what your lordship is.
Then ultimately the impugn order pays 155.
Yeah, impugn order is that, my lord, is 155.
So what he says that it will be under 24 1A.
Yes. So that is the issue, my lord.
Now,
Because your lordship will take note of the fact that the land was in our possession.
for that you have to pay surface compensation.
No, that is all right, my lord, but if subsection 2, that interpretation of subsection 2 of 24 will be very important.
Okay, we'll continue. Now, other part is okay now.
Yes, sir.
Subsequent single bench judgment is in continuation of the division bench judgment.
Yes.
And there are two parts into it. One is prior to section 4 and other is prior to subsequent to section 4, whether it had reached the stage of section 11 in the form of an award.
Yes.
And if not, then 24 1A will apply. Or if it is there already award, then 24 1B.
Even if it is not there, my lord, then the possession is with us, my lord. That is also, that is the my lord. issue you have-
Possession is not the
compensation.
sole requisite for acquisition.
My lord, I'll submit on,
Ownership is also important.
my lord, I'll submit on that.
Requisition is possession.
Now, my lord, the facts are clear, only now.
You are in possession by virtue of right to entry.
Yes.
Correct.
You are not an encroacher, but you are in possession by right to entry, like requisition. Requisition, you get the possession, do not get the ownership. But acquisition is ownership plus possession. You have only one.
Whether that will, my lord, come in my favor or not, that is what, my
Okay,
lord, I'll submit.
I,
before you on the next day.
Mr. M.K. Choudhury, Land and Cedar Council, listed by Mr. K. Kolita for the petitioners in part. List Ms. G. Goswami, Mr. Dinath, Learned Senior Government Advocate for the state respondents, and Ms. G. Goswami, Learned Counsel for the respondent number
5.
5 are present. I'll list the case on 6-1.
I have no objection, but my lord, immediately after vacation, there will be a rush. That is what, I don't have any objection to that.
Yes. Then thereafter, a long vacation.
Yes.
Can it be on 20?
Yes, sir.
20.
I think that will be.
Yes, yes.
2001
There will
2000.
be less.
25 6 as part heard.
Pleasure.
J and extending council revenue 1 to 3. Then Mr. Nath is 4. Okay, 4. And Goswami 5. You are? Okay.
Very obliged.
Obliging.